single unmarried lady. Hmm? In unmarried lady. So within upon rehabilitation upon the acquisition of land that has been challenged by the MCL and that order has been stayed. Collected anti-rehabilitation order. That the MCL has challenged that order. Already been posted for more than 10 years.
My Lord, WPC number 419/2016. Matter relates to Section 13, Clause 8 of Surface Act. I may be pardoned, my Lord. As per your order dated, my Lord, 19th November 2024, the matter was to be listed in week commencing 9th November 2024. But
Item 1. That case is directed.
Let him call.
Item 44 depends on detention matter that may be taken up.
Which you are going to release from.
WPC number 1404 by 2011 is a free time.
Quickly list item number 1.
2012, as they mentioned in the imputed order in the award, the petitioner has applied for the copy of the imputed order, but due to his accident since last 3 months, he is getting.
No. What you are challenging here?
Well, in the order, rejection order by the amnesty 2, page 15. In that order, page 16, the authority has mentioned that the award was passed on 23/7/2012, second para. My Lord said directed to file that order with the amendment petition. He has applied, but due to his accident last 3 months, he is busy. 2 lakhs has been
Yes.
retired person. I pay some time.
Just a minute. As it seems from the improved order, award was passed on 23/7/2012.
Yes, they have mentioned that
And,
also directed to file that order.
And you were also noticed to receive that award, but you did not receive that award.
They have first time the petitioner received amnesty award. Thereafter, they have filed the application for 3G for higher compensation. When they have not considered, he has moved before this honorable court. This honorable court in 2023, in writ petition number 3996 of 23, directed to dispose within 4 months. Now he has rejected on the ground that the award was passed on 23/7/2012. There is no notice, no award issued to the petitioner. Therefore, my lord is directed to file that in order.
Oh,
He has applied for a due to accident last.
so whatever you are telling that is not reflected in the order in any of the three orders passed till today. But have you taken any ground in your expedition that you have not received or you have not been served with that award dated 23/7/2012, which was issued to you with a notice?
Page 5, paragraph 3. I have mentioned.
Page 5,
Yes.
paragraph 3.
Yes.
Whatever.
First paragraph. That the applicant will give proper award.
Paragraph,
after
page
that,
number,
after
page number, page number,
Page number 5.
yes. Page number 5.
Opposite part number 1 give proper award as per the Kisam land reflected in Tahsil record after receipt of the application. First time the opposite part
କୋଉଠୁ ପଢୁଛନ୍ତି?
first paragraph.
ଫାଷ୍ଟ ପାରାରେ ତ ପାରା ନାହିଁ ସେ ତ
ଗୋଟା ମଝିରୁ ଆରମ୍ଭ ହେଇଛି
ଆଜ୍ଞା
କେତେ ଲାଇନ୍ସ କହିବେ ନା
fourth line below.
fourth line from the top or bottom?
Top.
Yes.
Land reflected in the top record after receipt of the application. First time the opposite part 1 issued award notice by sentence of 33/2021 by awarding compensation. That is annexure 1. First time.
But you have not specifically stated that you have never received the
yes.
award that is passed on 23/7/2012 or the notice, no notice has been issued on 5/2/2012. That type of specific awardment you have not taken. If you are disputing something that prior to the particular date, as you said, in 2021, you have never been served with the copy of the award or no notice has been issued. Whether it was required on your part to mention those aspects in the petition or not. And what about that award which was passed in 2000?
Para 6, page 8. The application of some before issue of annexation, the opposite parties also have not followed the section 3A, B, C. First, para
Petitioner
page
said that
first,
annexure 1, the opposite parties 1 and 2 have not followed.
there was a no in the fourth line. 1956.
Page number
8.
Page number
8.
Page 8. Para 6. Fourth line after 1956, and there was a no any notice except annexure 1.
No, individual notice is not to be served. It's a
No.
publication. It's a publication. No individual notice is to be.
After award they have issued.
Yes. But how could you know that the value has been determined on the basis of agricultural land? You claim that your land has also been taken as homestead land.
Yes.
Where is that order? Where is that ROR? Homestead.
Yes, I have also filed it before the collector.
No. Is there any order after that? You have moved the authority for conversion of land from agricultural to homestead. Has it been converted?
Yes.
Where is that?
Where is that?
I'll file that.
That is the basis of your claim and you are not filing it.
This writ petition has been filed by the petitioners, Jagobandhu Jana, Satyanarayana Jana, and Sadhana Jana. For quashing the order dated 9/1/2024 passed by the arbitrator from Collector Dhinkana, bracket the opposite party number 3. by annexure 2 and for a direction to the opposite party number 3 to adjudicate the petition under section 3G bracket 5 read with subsection 7 of National Highways Act within a stipulated time. So, from the impugned order, it appears that the opposite party number 3, after hearing both the parties as per the order of this court passed in the earlier writ petition, that is WPC number 39996 of 2021, has been pleased to hold that the award in the case was passed by CA and LAO bracketary opposite party number 1 on 23/7/2012, and notice was issued on 5/2/2013 to the awardees to receive the payment on 13/2/2013. It is further stated in the order that the petitioner has not submitted any authenticated documents before CALA that the case land has been converted Bharwari Kisam to substantiate his claim. The Land Council for the petitioner submitted that neither he has received the copy of the award which is stated to have been passed on 23/7/2012, nor any notice which is stated to be issued on 5/3/2013 to receive the payment. And for the first time, by virtue of annexure 1, which is dated 31/3/2021, he came to know about the passing of the award. However, he submits that he has applied for the copy of the award dated 23/7/2012, and some further time we granted to him to produce the same. He further submits that the petitioner is having the authenticated document to show that the case land has been converted to Bharwari Kisham, from agricultural land to Bharwari Kisham, to substantiate his claim. Put up this matter on Quebec only. Get the sum of the time.
3 weeks, sir.
3 weeks time. Put up this matter in the week commencing from 17th of February 2025. Copy of the award dated 23/7/2012 to also authenticated document showing that the case land has been converted from agricultural land to Bharwari Kisam that we filed on the next day, giving copy to the Land Council for the state. Yes.
Item 2.
First order, this honorable court may be paid. Order dated.
He perished the order dated 21/10/2024.
That liberty, your lordship, has been erroneously taken by my associate, because pursuant to the first order dated 21/10/2024, the affidavit had already been filed on 11/11/2024.
That affidavit doesn't speak about the direction issued in 2110. Kindly read 2110.
2110.
Third paragraph. Learned counsel for the petitioner.
Learned counsel for the petitioner due attention of this court to the earlier order passed by this honorable court in WBC number such and such, wherein holding that the procedure which has been followed by the authority in cancelling the allotment of land in favor of the petitioner was just and proper, and it was observed if the petitioner prefers to give the market price prevailing at the time of filing of application and comes with a project to be started within 6 months, it would be open to the opposite parties to allot the land in question in accordance with law.
Then
It is the contention of the learned counsel for the petitioner that after passing of the order by this court in 2019, the petitioner submitted the application before the authorities for allotment of the plots, but the authorities slept over the matter and ultimately passed the impugned order under Annexure A. It appears from the case record that the application made by the petitioner has not been annexed to the writ petition, and learned counsel for the petitioner seeks some time to produce such application.
all right. So the application which you claim to have submitted before the authority, which you also assert that the authority set over it, was to be filed by you.
Yes, sir.
Have you answered it in your
Yes,
affidavit?
Your Lordship. In my affidavit dated 11/11/2024 may be seen here, wherein I have annexed Annexure 10,
Annexure 10.
page 8 of that affidavit, Your Lordship. It is dated 13/1/2020.
No. Where is it acknowledged? How did you send it? How was it registered post?
By register post. It has been, the said application has been gotten from the RTA Act.
Under the RTA Act.
Yes, Your Lordship.
All right.
The affidavit is at flag B, man.
Flag B.
Flag B.
Kindly come to the paragraph where you mentioned about submission of application.
Yes, my lord.
Annexure 10, no?
Yes, my lord.
Para 6.
Para 6. It is humbly submitted that after obtaining the certified copy of the order dated such and such, I immediately applied before the ITCO authorities by letter dated 13/1/2020, wherein I had filled up the form which was prescribed earlier. As I do not have the copy of the aforesaid application form, nor is it available in the online portal of ITCO, thus to procure the same, I have applied for its copy through
Affidavit. Flag B. Affidavit.
Para 6.
Para 6. It is page 110 of my laws.
Okay, please read it once again.
That it is humbly submitted that after obtaining the certified copy of the order dated 13/12/2019, I immediately applied before the ITCO authorities by letter dated 13/1/2020, wherein I had filled up the form which was prescribed earlier. As I do not have the copy of the aforesaid application form, nor is it available in the online portal of ITCO, thus to procure the same, I have applied for its copy through RTA dated 25/10/2024, and I have procured the online copy of my letter/application dated 13/1/2020 from the web portal of the ITCO. They have downloaded it from their web portal and have sent me that. The Annexure 10 communication. It is signed by Duryodhana.
Then what happened?
Then, my lord, by Annexure 12, they sent me the letter dated 18/3/2020, wherein that is page 12, my lord. Wherein, in pursuance to the order of the Honorable High Court in WPC number such and such, you have requested to establish a new unit in ITCO plot number 27, 28, and 29, area measuring 1 acre. You are requested to submit your application through online along with project report, layout plan, and EIN registration certificate of DIC of the proposed new project for taking further action at our end. Then, my lord, Annexure 13 may be page. The next page. The same was complied with by my online application dated 19/11/2020. It is their admission. In consideration of your online application dated such and such and recommendation of the divisional head IDCO Jajpur Road Division dated 3/12/2020 on captioned subject, it is to intimate that in pursuance of the order dated such order of the Honorable High Court in such and such, the management of IDCO has agreed in principle and allowed to apply in fresh in afresh through single window committee for allotment of land on payment of today's market price / IDCO rate, whichever is higher. It is the letter dated 18/2/2021.
Yes, what up?
Post that, my lord, my peruse the writ petition, annexure 8. The decision was taken in the year 2024, Your Lordship. Sorry, my lord, I stand corrected. It was taken on 15/4/2023, after 2 years. Annexure 7 may be perused, page 68 of my report. There's a, they have made a pointer, MS Bhubaneswari construction, in the middle of the set. In that, Your Lordship, the last portion may be perused. They have considered my application and allowed the same.
Yes.
But they again sat over it and vied annexure 8, my lord, page 74, in the year 2024. The letter is dated 29/8/2024. They have finally communicated me that I have to give the cost of land at 94,44,700 for 1 acre.
So what is your submission? That
My submission is that
there was delay on their part.
it is a delay on their part. First, first point of contention, Your Lordship. And further, with due respect to this honorable court also, my lord, the IDCO has a regulation in place which empowers them under section 7 of the IDCO Act, wherein the board of directors are empowered to take decision by fixing the land rate of industrial estates, Your Lordship. The subsequent annexure may be seen, annexure 9, page 75.
No, this annexure, if you are facing that annexure 13.
Annexure 13.
Yes, which you have filed with your affidavit.
Yes, madam.
That's shows that they have allowed you to file the fresh application.
Again, a fresh application.
And this is dated 18/2/2021. Then you filed the fresh application. Yes. And the order was passed in your favor.
Order was passed in my favor by the TLSWC meeting.
And that order is
15/4/2023.
Yes. That is annexure 7.
That is annexure 7.
Okay.
And subsequently, after a year, 1 year and 4 months, the IDCO authorities made the notice dated 29/8/2024, that is annexure 8. Wherein the land rate is fixed in accordance to the market price prevailing in the year 2024.
Yes.
So I have 2 legs of submissions, Your Lordship. First thing is that the IDCO authorities cannot take the advantage of the delay made on their behalf. Even if it is assumed that in pursuance to the annexure 13, I have made my application in the year 2021, not even in 2020. The land rate, it's my second leg of submission, that it should have been fixed in the year 2021, or otherwise on the date of first communication, that is 2020.
So according to you, there is already a revision of the land, rate of the land. Subsequently,
no,
after
my lord,
2021.
There is no revision.
Then
rather, for the industrial estate in Jaraka, the land rate was fixed in the year 2019 by the board of directors. The same has not been revised as of yet.
So then how you are prejudiced?
That because the land rate is fixed at 25 lakhs per acre.
No, you said that 2019, a particular price has been fixed for a land, and that has not been changed.
Yes, sir.
So if that has not been changed, you are thinking that perhaps because of their delayed communication, in the meantime, the land rate has been enhanced, so that is how you are to
No,
make
my lord.
extra payment. So then how you are prejudiced?
I apologize. There is some there's a fault in my part to convey the same. My lord, if the land area may be seen in Annexure 8, it is 1 acre of land. In Annexure 8, the land allotted in my name previously, over which I am still possessing it, it is only 1 acre of
That
land.
is what we are saying. So for 1 acre of land
The
in 1990, the rate was 25 lakhs, according to you.
2019, my lord.
In 2019, the rate was 25 lakhs.
It is still existing as of now. The said rate has not been ratified by the board of directors.
Then how this later, that is how you are saying that arbitrary?
Yes, my lord.
How?
Because, my lord, as per Annexure 7, as per Section 7, I humbly apologize, as per Section 7 of the IDCO Act, the board of directors are empowered to take decisions in accordance with the regulations in place. There is a regulation of IDCO with regards to fixation of the land rate inside the industrial estates by the board of directors.
Yes, in course of time, number of industrial houses have come, enhancing the rate of the land. That is how they are regulating the price of the land.
To that effect, my lord, I have also filed Annexure 14.
14.
14.
Right.
That is page 121 of my lord's bill. Therein, the revised rate of certain industrial estates have been given. Subsequent to Annexure 9, my lord.
Right.
But in that
that is confined to some districts.
There is no mention of industrial estate present in Jharkhand. So the land rate for 1 acre is 25 lakhs. But herein, in Annexure 8, they are charging me 94 lakh 44,700. That is my whole bill.
Where it is mentioned that 1 acre is 25 lakh?
My lord, may peruse page 77. The district has been specified in column 2 to be Jajpur, and Jharkhand is the first noting in the third column. The figure is written in lakhs, my lord. Approved land rate per acre. So it is 25 lakhs which has been fixed by the board of directors for 1 acre of land. And the initial allotment was for 1 acre of land. The second allotment which is being done by Annexure 8 is also for 1 acre.
Petitioners, Messrs. Bhubaneswari Construction, represented to its sole proprietor, Duryodhan Jena, also Duryodhan Jena, have filed this writ petition for passing the demand notice dated 29/8/2024 issued by the Chief General Manager Finance Report Secretary, opposite party number, Chief General Manager MSN,
opposite
party number 3. On perusal of Annexure 8, on perusal of the impugned letter, it appears that for the allotment of CIDCO plot number 27, 28, and 29, measuring 1 acre at IE Jharkhand. The management approved the same in favor of the petitioners, wherein the cost of 1 acre of land has been mentioned to be rupees 94 lakh 44,700. The petitioner was asked to deposit the same, the said amount along with the annual rent and annual IMC for the year 24-25 within 30 days from the date of issue of the letter, failing which the proposal shall not be considered, and it would be construed that the petitioners are no more interested for the allotment of land and not interested in any further progress of their proposal. It is the contention of the Land Council for the petitioner that the IDCO has issued a circular in the year 2019 in pursuance to the decision of the Board of Directors, which was taken on 25/10/2019, wherein the cost of land in respect of the industrial estate oblique area in Jharkhand has been mentioned to be rupees 25 lakhs. The Land Council for the petitioner submits that after 2019, no press circular has been issued by the IDCO revising the rate of land or acre. Therefore, the demand which has been raised by the opposite party number 3 under Annexure 8, asking the petitioner to deposit 94 lakhs 44,700 per acre is illegal, and the same is contrary to the circular issued by the IDCO authorities under Annexure 9. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice to opposite parties be filed within a week. Matter will be stayed after 4 weeks. Counter affidavit, if any, be filed in the meantime. Yes, please. No, we do not know whether that land is still there or not, because you have delayed in approaching this court.
The land is still there
We
because
do not know that
because they have
you
also
see, Land Council, the letter was issued on 29/8/2024. You are giving a month's time. That month's time is already over since September 2024. Now we are in January 2025. We do not know the status of the land. If
Lord,
it
they
is
have-
there, the authorities say that then after hearing, necessary order will be
they have issued a letter
this
of reminder.
I also appropriate order also issue notice and accept one set of process fees. Yes, next.
Lord, they have also given a reminder for payment in the dated
All right,
form.
let them appear. Let them appear. to communicate the order to them.
Item 3.
You want adjournment? Now the judgment has been pronounced, it has not been extended. Come to the order number 1. It's all right, but for your knowledge, we have to say that on 3rd of January 2025, the order has already been, judgment has been pronounced, and that term of the claim commission has not been extended. Clear? So the learned counsel for the petitioner seeks for an adjournment put of this matter.
Item 4.
Item is 4 million. This case, my lordship directed to the submit the report regarding the status of the land.
Yeah.
But till date we are not received the report. So I pray once my lord that may be given the last chance. I can.
Who is to submit the status?
That is the
What for?
GA department.
GA department.
Yes, the honor. Next week we have the last chance. So that
Otherwise, we will ensure the appearance of that commissioner cum secretary of the GA department through virtual mode. Right? The learning council for the state seeks some more time to obtain instruction regarding the status of the land. The first order was passed on 27/11/2024, wherein this court has asked the learning council for the state to obtain written instruction regarding the status of the land. As the petitioner stated to be in possession of the house in question in Panitanki Bosti area of Chandrasekharpur, Bhubaneswar. Thereafter, the matter was adjourned to 9/12/2024, 16/12/2024, 6/1/2025, and the Learned Council for the state has again sought for adjournment as a last chance. Put of this matter in the week commencing from 27th of January 2025, if we make it very clear that if on the next date the Learned Council for the state will fail to obtain instruction regarding the status of the land, the commissioner cum secretary to the government, the General Administrative Department, Bhubaneswar, has to make his appearance to virtual mode to answer as to why he has tried the orders. This court passed 27/11/2020. So said order by the council of the state has submitted stock. Yes, next.
Item 5.
The second one is the petition. The petition, the available loan in the year 2020 of registration 34 lakhs in order to run this business. Accordingly, on the past occasion, the petition made an appeal to they were directed to consider the same, but they Bank patrol they have not considered the application of the
No, what
petition.
is the position now?
Position now they have issued the possession notice.
So,
That is annex of core on the guideline.
so you go to the alternative remedy.
No, Lordship, I have already filed a
Essay filed.
Father, no, Lordship, I have filed the application in order to clear up all the dues.
No, that prayer can be made also
No,
there. If any pending essay is there before
no,
the
essay.
essay, no, so you go file and file the
No,
essay.
Lordship, I have filed the memo, Lordship, is taken up the matter on the next local further. Secondly, this could whether the though the petition is ready to clear up all the dues.
Make that statement by filing the essay. It will be like.
So you are granting liberty to
Want to how
only
granting
move an application to the
alternative remedy is available. Yeah. Yes, next.
Item 6.
Are you filing any memo? Please file it. You want to file it with better particulars. You are seeking for liberty.
No, my lord, with liberty to approach the appropriate forum as the borrower has already filed the essay.
Correct.
Essay has already been
The
filed. It's posted tomorrow.
memo has been filed for withdrawal of the writ petition. Memo is taken on record. Writ petition is disposed of. And please, Mr. Give your name and appearing for the Punjab National Bank. Yes.
Item 7.
Yeah. You have given the after making necessary correction.
Item 8.
I'm appearing LLC in DC.
My lord, this limited term for the lordship might have while issuing this order on 13 for the Surprise Act, they have not followed observed, my lord, they have not followed the section 13. I have raised the objection 33A only for a direction to provide me details of in the mind their 13 to notice details of the my lord code asserts. They have not given, even though the mandatory provision under section 13(3) is to give the details, my lord, account statement and the property which is to be auctioned, my lord. And the Annexure 7, my lord, here is objection.
Possession notice has already been issued. That is Annexure 7.
Yes, Lordship. That is symbolical possession, Lordship.
Go on.
My lord,
Possession notice is under challenge. Alternative remedy available.
Lordship, let me file the counter regarding the statement what.
Why to file counter?
We are disposing of. We are recording your name, Mr. Parma. Appears to. Yes, next item number.
Item 9.
Representation is Annexure 5. 2022. Which is the date?
2022 is
No. It is mentioned there are two dates in Annexure 5.
representation will be receiving money in compensation amount. There are
Mr. Counsel,
Try to
we are
understand.
just to we want to know that which is the date of this application.
Whether 2010 or 15/10/24.
Last representation 15/10/24.
Data kind of delay.
এইটা সেই 22 মিটার দিয়েছিল পুনি তাকে আউথরে এই দিন
And
without sending it.
the Annexure 5 which is stated to have been submitted on 15/10/2020. Before who is to dispose of?
Opposite party number 2.
Opposite party number 2, Collector Mayurbhanj.
In all these cases.
So all these cases.
Opposite party number 2 and 3. Special indication officer.
ଦି ଜଣକୁ ଦେଇଛନ୍ତି representation ନା ଜଣକୁ ଦେଇଛନ୍ତି? ଆରେ ୟା representation ଦେଇଛନ୍ତି ସିଏ କରିବ ନା?
ଆଜ୍ଞା
ଏଟା ପରା
two na three.
Land acquisition officer.
Two packets in representation 3 କରିଦିଅନ୍ତୁ ନା not 2. disposal. Yes, next.
Item 10,
10, my lord. Take some time to take instruction from the collector Khurda about the status of the section 14 application.
कौन होला?
14 was pending. Section
अच्छा,
One will take.
तो आपण नहीं ना
Nine,
instruction.
9/7/24
Okay, so get it by next week.
Next.
Plan and counsel for the, you have already communicated. Plan counsel for the state submits, that communication has already been made to opposite party number 1.
collector
That is collector and district magistrate Khurda for obtaining the status of the petition under section 14 of the Surface Act 2002 filed by the opposite filed by the petitioner on 9/7/2024, and the matter may be taken up next week. And you get to receive the instruction, and the matter may be taken up next week. As prayed for, this matter on 27th January 2025. Yes.
item 11,
The consideration of the litigation under annexure 1.
Yeah, next year pending.
Annexure
Barbara,
1 is-
annexure 1 is
Annexure one
time.
Minor kindly discuss.
Annexure 1 to application for disposal of my prayer marking. Annexure 1 to
OP3 will be considered. OP3 is to consider.
OP3 is to be disposed of that, है ना? Annexure 1, OP3. Yes.
item 12,
May I please, your lordship? My lord, only my lord, prayer is that my land has been echoed by the NSC. That has been proved, page 17, that is the judgment of the competent civil court, which has attained its finality because it has not been challenged anywhere. Thereafter, after a long interval, page 19, the NSC authority wrote a letter on basis of my long-standing request, wrote a letter to the Director Municipal Corporation, the Municipal Administration, to take initiative. The last is therefore requested necessary government order suggestion for acquisition of land. Then page 20, my lord, that letter, the answer of that page 19, the Housing and Urban Development Department, referring that letter, issued a letter to the collector, furnish your valuable opinion in this regard to this department. This is pending, my lord. Here actually the authority is the Director Municipal Administration to take initiative for in consultation with the Department Urban and Housing and Urban Development Department. Without taking any action, they are now wrote a letter to the collector to furnish your valuable opinion. Can any opinion will exceed the beyond that order of the civil code, my lord?
Yes.
Yes, my lord. If any opinion is necessary, the collector should have given it.
No opinion in the sense, suppose
Yes.
it may be that they have challenged
Yes,
the order.
yes.
So that is why they want the clarification that if the order is not challenged, obviously it is to be. But you are right that that is about a year has passed, and so just obtain instruction whether any response has been given by the collector to the letter dated 31/2024 or not. That is annexure.
There is a declaration.
Lordship may discuss by directing the collector. Actually, they have not given any.
Actually, ଆପଣ ଯେମିତି କହୁଛନ୍ତି ମାନେ
your lordship kindly see the situation because it's a case 2017 order. Why I have come before your lordship?
No, you have not received the. That's a different matter. Question is that suppose any other party might have approached, or the state might have. Who knows that is the reason why.
If that is so, the collector should have report the
ଏଇ ତ ବୋଧେ collector report କରିଛନ୍ତି କି ନ କରିଛନ୍ତି ସେଇଥିପାଇଁ ତ କହୁଛୁ ଆମେ.
Your lordship may say that pursuant to the 24/11/23 order that at page 19,
तो collector may comply the same.
Yes, you obtain instruction.
Is the arising out of suit for declaration.
अरे suit order टा तो अपन payment ताले कौन नहीं दिखाएंगे?
I'll take it.
Suit order टा तो favor रही ना?
नहीं सर, तो लेकर जा acquire the land.
Acquisition process of acquisition will be there and determination will be there and it will be awarded.
Yes, 17 mechanism.
It is the declaration is only for acquisition of land.
Yes.
Whether that acquisition process has been initiated or not, that has to take. Then
No, nothing has been initiated.
No, that's right. Then the
For
question
that
of
reason, I
compensation will
compelled
come into
to take shelter before this record.
All right. The writ petition has been filed by the petitioner C.Sahoo.
Declaration ଟା ଏମିତି କଣ ହେଇଛି? Civil suit declaration ଟା ଏମିତି କଣ ହେଇଛି? You may ask for declaration of your right, title, interest and possession. And where is the court is barred under section 9 of the Civil Court Act. There is a OPLA Act. The court is to direct the authority to proceed under the OPLA Act.
Court only directed to evict.
How
If you are not evict,
court
then
cannot direct for an
yes,
acquisition. If there is an encroachment, OPLA Act will take into
applicable now. So
direction anyway.
The what is your prayer in? इसके बोलता कौन बोला लेकिन?
prayer.
Caption देखो ना prayer लिख.
Prayer is used for
very very.
representation ଯଦି ଦେଇଥାନ୍ତେ that would have been sufficient.
ନା ନା ମୁଁ representation ତ ଦେଇଛି.
Representation ଦେଇନାହାନ୍ତି ସେ କହୁଛନ୍ତି ଯେହେତୁ direction already ହେଇଯାଇଛି collector କୁ
collector
that is to be compliant.
that would have handled to this honorable court to
prayer देखी लिखी देवे. जोड़ा main gist prayer लिख देवे. It is submitted by the learned counsel for the petitioner that the petitioner instituted civil suit number 50 of 2014 for declaration and for eviction of defendant number 2. Defendant number 2, executive officer, Area Road NSC from the suit land and for recovery of damage from the defendant. And the learning civil senior civil judge Nuapada by judgment and dated 4/3/2017 has been pleased to pass an ex parte decree against defendants number 4 and 6 and on contest against the other defendants and directed that the
in fact this suit would not have been entertained with respect to
suit
the
for eviction.
suit
for eviction was there.
Yes.
The encroachment of the suit land by defendant number 2 was declared to be illegal and he was directed be evicted from the suit land. And it was further ordered that it is open to the defendant number 1 and 2 to acquire the suit land for the purpose of mini stadium and road of Area Road as per law. The land counsel for the petitioner submitted that after receipt of such judgment, the additional secretary to government has made a communication to the collector and district magistrate Nuapada bracket opposite party number 3 for information and necessary action for furnishing valuable opinions in that regard and for taking necessary action. And even though the letter was issued on 30/1/2024, but no response has been submitted by the opposite party, number so and so, collector and district magistrate. Let the learning council for the state obtain instruction as to, after receipt of annexure 3, whether the collector and district magistrate so and so has passed any order or not, and whether any steps have been taken for the acquiring the land of the petitioner as per the judgment and order passed by the land senior civil judge Noapada under annexure 1. ଗୋଟେ ସପ୍ତାହ ପରେ ଆସୁ ନେଇଯାଅ instruction. Lease this matter in the week commencing from 3rd February 2025. Here.
Item 13.
Annexure 3 is your representation. केबे देले 8/5/24 किसी communication पाइनांती. अच्छा हो. Annexure 3 will be disposed.
Item 14.
Yes, Mr. Rajara.
Disposal of the
अच्छी order.
order ता पाइने तापर मु order भी annexure करते annexure 3.
केदे annexure 3.
Page 17. Page 17.
अच्छा annexure 3 रे जो order है जी.
Last month रे 12 टा
annexure 3 रे जो order है सी order करते जाओ. आदरे बाकी सब opposite party number 3 तो.
Yes sir.
ठीक है. तो उधर number disposal.
Item 15.
In this case, my lord, technical service of the ICIR.
You are challenging the order of the Land Central Administrative Tribunal Cuttack Bench. 24/10/2024. What is that? Annexure 12. Please come to that. What was your prayer before the Land Administrative Tribunal?
Prior that, Honorable High Court directed that and quashed the order of State Administrative Tribunal to direct to pass appropriate order for law and directed this matter covered for the judgment of Supreme Court.
No, you see, this matter is running from 2007 or something, 2009. So give us a date chart. What has happened, what order has been passed, because it appears that you have earlier approached, then it was remanded, then the, so just give a date chart, otherwise it would be difficult. Date chart is there. Kindly.
In this case, my lord, the technical service benefit petitioner challenges the benefit of technical service.
By the way, what is your ultimate prayer? What you want? Your arrear salary with benefit.
I granted my arrear salary and benefit on the basis of Honorable Supreme Court judgment and Honorable High Court judgment. To Annexure 5, Page 24. And Honorable High Court also directed fast my lord on
No, it's all right. As per the order of the Honorable Supreme Court and this court, you got your salary.
The promotional benefit is not granted till date, As per Annexure 1, madam.
So what you have already got, what you are not, what
They
you
are
have
not
not.
granted till date, madam. The
Or
benefit of
the
the technical service benefit granted till date, madam. Under Annexure 1, madam. Till date, we are challenging that. Honorable High Court categorically already stated on the order dated.
Acha, you come to Mr. Counsel, please come to the internal page number 11 of the Central Administrative Tribunal, which is in running page number 70. Upon number the Nadia through what come to the confused. Internal page is 11, paragraph 9. Paragraph 9, internal.
From the above, it
Yes.
is clear that the case of Sri Bibi Naik, different
Actually,
since his claim was for the pay scale 425 600 with effect from 110 1973, it should be rates
20 to 700 or 25 to 700. What of it?
As per with senior computer, as he was placed at a lower pay scale
in that case,
अरे कौन आपण
नहीं सीट पढ़िबार असुविधा होछि
lower pay scale in that scale, thus ICAR accepted the segments of pay of Sri Naik in pay scale of 425 to 700 as computer with effect from 1/10/1973 as per the order of the tribunal, as the ICAR council did not object to that part of the tribunal's order before Honorable Apex Court as the observer in the judgment extract above. The order direction for the segment in pay scales of rates 550 to 900 by challenge. The said and the said direction of the tribunal was satisfied by the Honorable Apex Court and counsel for the appellant in the present way before us had submitted that the appellant was wanted the same benefit of 45 700 with effect from 1/10/1975, which was allowed to Sri Bibi Naik. But the present applicants pay scale of a 1/10/1975 was not at the rate 425 to 700, like the case of Sri Bibi Naik. Hence, it is held that the case of appellant is not at the the case of Sri Naik. And hence they are not entitled to the benefit of the claim by them this case. My lord, it is not correct now. In this case, my lord, petitioner the challenge the technical benefit of the service with the law the technical service rule come into force with effect from October 1, 1975. I am under category number 2. My position under category number 2, man. We are under the technical service.
He mentioned in paragraph number 10 that similar question came up for consideration in OA number 213 of 2007, and that OA was dismissed on 2nd December 2019, and he has quoted the order. Whether that OA has been challenged before this court. That OA number 213 of 2007,
my lord,
which was disposed of on 2nd December 2019. Because if it is challenged and this court has already accepted notice has been issued, then this writ petition is to be heard along with that.
Annexure 10, my lord, sorry, Annexure 11, my lord, Honorable High Court directed there. Sorry. Annexure 11.
ଏବଂ ଏଇ ଅର୍ଡରଟା ପରା ହେଲା ଡିସେମ୍ବର 2019 ରେ 2 ଡିସେମ୍ବର 2019 ରେ ଆଉ ଆପଣ 25/4/2019 ର ଅର୍ଡର କଣ ଦେଖଉଛନ୍ତି? ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି ନା ନାହିଁ କୁହନ୍ତୁ ନା ବୁଝିବେ? Please come to the paragraph number 10, page number 71. Paile, you see, we find that 4 lines from the top of that paragraph number 10. We find that similar question came up for consideration before this tribunal in OA number so and so, filed by the similarly situated employee so and so, and after discussing all the pros and cons of the matter, this tribunal dismissed the OA on 2nd December 2019. We are asking you a pertinent question that whether the said IA order or judgment has been challenged before this court or not. Or what is that number? And what is the result of whether it is pending or disposed of?
213 of 2007 OA has been challenged or not?
No, order dated 21/1/2009, man.
No, no, you are
କଣ ପଚରା ହଉଛି ଆପଣ କଣ ଆନ୍ସର ଦଉଛନ୍ତି? ବାବୁ ଆପଣ ଯୋଉ ଅର୍ଡରଟା ଯୋଉ ଅର୍ଡରଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ତା ଦେହରେ ଗ୍ରାଉଣ୍ଡ ଅଫ ରିଜେକ୍ସନ ଅର ଡିସମିସାଲ ଅଫ ୟୁର ଅରିଜିନାଲ ଆପ୍ଲିକେସନ ଇଜ ଦ୍ୟାଟ ଆଗରୁ ଗୋଟେ ସେଇ ଭଳିଆ ସେମ୍ ସିଚୁଏଟେଡ ଏମ୍ପ୍ଲୟିଜ ମାନେ ଆସିଥିଲେ ସେମାନେ ଓଏଟି ଫାଇଲ କରିଥିଲେ ତା ନମ୍ବର ହଉଛି 213/2007 ଯୋଉଟା କି ଡିସମିସ ହେଇଛି 2/12/2019 ରେ ଆମେ ଆପଣଙ୍କୁ ପଚାରୁଛୁ ସେ ଅର୍ଲିୟର ଅର୍ଡରଟା ଯୋଉ ପାସ୍ ହେଇଛି ଇନ ରେସ୍ପେକ୍ଟ ଅଫ similarly situated person whether it has been challenged before this court or not. ଯଦି ଜାଣି ନାହାନ୍ତି instruction ନିଅନ୍ତୁ ହେଲା ଦେଖନ୍ତୁ. The writ petition has been filed by the petitioners challenging the order dated 24/10/2024 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/0009 of 2007, in dismissing the original application, taking into account that similar questions came up for consideration before the tribunal in OA number 213 of 2007, filed by similarly situated employee styled as Natvar Mohanty versus Indian Council of Agriculture, which was dismissed on 2nd December 2019. Subpara. We put a pertinent question to the London Council for the petitioners as to whether the order dated 2/12/2019 passed by the London Central Administrative Tribunal in way number 213 of 2007 has been challenged before this court or not in any writ petition, the London Council seeks some time to obtain necessary instruction in that respect. Put up this matter on week commencing from 3rd February 2025. Whose name is to be reflected?
I am for OP number 2 and 3. Satyajit Behra.
The learned counsel for the opposite party number.
They didn't serve the copy of the same to the OP number 2.
2 and 3.
OP number 1. I am for the ICR counsel.
अच्छा the फाइल कर दीजिए अपन
नहीं मैं करी भी फाइल करी भी
ताले ये लिखिंग दियो भाई ये नान
हम नाटन
wants to submits that he has instruction to appear for opposite party number 2 and 3. Learned counsel, you have not served a copy on the Union of India. Union of India.
They didn't serve me.
Let a copy of the writ petition be served on the Deputy Solicitor General's want to within by next week or within during course of this week. Hello? Yes.
Item 16.
Yes, Mr. Sahu.
Here in this case, my lord, the present petition obtained a loan for construction of a school, my lord. And after obtaining the loan, he has regularly paying, my lord. All of a sudden, due to some miscommunication, my lord, could not able the pay the amount.
14 proceeding has already been initiated
Yes,
before
my
the
lord.
collector. So
I'm
have you
ready.
come here?
Well, some time required for
Go there and ask for time, whatever you want to.
liberty may be granted. I will
As it appears that since the petitioners who are the borrowers didn't pay the dues in time, proceeding under Surface Act was instituted, and now the order has been passed by the London District Magistrate Ganjam bracket legion to a comma division opposite party number 1 in a proceeding under section 14 of the Surface Act. So on the application filed by the authorized officials, so that is opposite party number 3. After imbue of some distance and the remedy is available to answer, he has to take the course of dispose of it.
Item 17.
पेंसिलটা ইয়ে করে সঙ্গে সঙ্গে বড় গেলেন ওটা ধুয়ো এগুলো তলে পড়লো জিনিসটা মোটরটা না
challenging the inaction of the opposite party number 2, 3 and 4, not releasing the amount, enhanced awarded amount to the petitioner, which is the order has been passed on 24/7/2023. The facts of the case are this. The land has been acquired for Rengali right canal system, Rengali in the year 2016 by notification by the state government, and thereafter award has been passed on that under Annexure 1, your lordship.
No, thereafter you file an application under 64.
Yes, sir.
So what order was passed?
Order passed under Annexure 3.
Annexure 3.
Yes.
So whether that amount was enhanced or not?
Yes, your lordship, enhanced.
Then what happened?
My lord, lordship kindly come Annexure 4, your lordship.
For a chronology.
What is it? Dakile amko. Yeah, so receipt kariya, payment kariya, and on 27/9/2024 notice has been issued.
9/2024
Again, 7/10/2024 affair kariya कहले. We have submitted everything, but till today they have not released anything.
No, you have submitted everything by way of মানে কিছু documentary
receipt খালি সে receipt তৈরি করিও কা account রে কেতে deposit হবে
না না ভোট পরিচয় পত্র আধার কার্ড সব মাগি
ଆପଣ ସେଟା ତ ଗୋଟେ application ଜରିଆରେ ଦେଇଥିବେ ନା ଖାଲି ଦେଇଦେଲେ
ଆଜ୍ଞା
you have stated that you have in affirmation taken in the repetition that you have
complied with
the notice under Annexure 4 per 40. annexure 4 आपन कहला ए डॉक्यूमेंट लेकिन आसंतु तापरे आपन को अकाउंट को जीवो कोठी लिखि जंती जे
Passbook,
तापरे
account.
आपन आनी सब डॉक्यूमेंट गुडी को अथॉरिटी का पाकर देले ता सत्ते मध्ये आपन को अकाउंट को पैसा पठा गला नाही
Well, all this left over the matter in spite of my
Then
request.
unless you comply.
ଆପଣ କମ୍ପ୍ଲାଏ କରିବେ ନା ଅଛି କଣ ତେଣୁ ଯାହାକୁ ନେଇ ତାକୁ ଦେଇଦେବେ କି ଆପଣ ରାମ ଦାମ ସାମଙ୍କ ନାଁରେ ଅର୍ଡରଟା ହେଲା ରାମ ଦାମ ଆଣିକିନି ସେ ଡକ୍ୟୁମେଣ୍ଟ ଦେବେ ଯୋଉ ଯୋଉ ଡକ୍ୟୁମେଣ୍ଟ
Bank passbook ଦେବେ, IFSC code ମାଗିବେ।
ଏ ସବୁ ଜିନିଷ ଦେଲେ ସିନା ତାଙ୍କ ଆକାଉଣ୍ଟ କୁ ଯିବ
Attestation of by
Specifically, my instruction is that I have submitted all those
Government
documents. In fact, my lord, it is not specifically I mentioned in my writ application.
nothing has been mentioned.
No, my lord, I have not mentioned. My lord,
instruction neither
letter.
You mean to say that you have already
Yes,
submitted?
Lord.
All right. This writ petition has been filed by the petitioner for a direction to the opposite party number 3, special land acquisition officer, so and so, and opposite party number 4, zone officer, zone 3, so and so, for early disbursement of the enhanced award amount passed in LA case number 34 of 2021, decided on 24/7/2023 by LAR authority within a stipulated time. The Lieutenant Counsel for the petitioners submitted that the petitioners filed an application under section 64, read section so and so, before the zone officer, zone 3 Rengali, right canal system, Tenkana, and the same was registered as land acquisition case number 34 of 2021, and that came to be disposed of by judgment, and এটা কোন রেফার হয়ে গেল তারপরে তো which was referred to the so and so, and it was disposed of by the presiding officer so and so on 24/7/2023, and it has been held that the petitioners are entitled to get compensation and also statutory solatium with interest. And after the order was passed, the petitioners were issued notice by the annexure 4 on 24/9/2024 and were asked to deposit, produce different documents, and in pursuance of such notice, though the petitioners have complied the requirements, but they have not been disbursed with the compensation amount. Let the Lieutenant Counsel for the state obtain instruction as to whether in pursuance of the notice under annexure 4, the required documents have been submitted by the petitioners or not, and if so, why there is delay in disbursement of the awarded the compensation amount. Put up this matter. Keber rakhiyo apuntu. 10th of February 2025. Yeah.
Item 18.
May I please have the opportunity to complete? This matter is related to land acquisition. Order passed by this honorable court by order dated 29/2024.
Similar order you can make
Who order?
You want similar order to
Annexure 2 order.
Annexure 2 has been passed by us.
अच्छा से जजमेंट खाली डेट फेट आउ चेंज हबो तो ये गुडा को केस नंबर आउ सब समान रहइबो एमजेसी नंबर एगुडा को कौन मार्क कर दीजिए जोड़ा चेंज हो कौन मार्क कर दीजिए और ये भी सी अपर इंद्रावती इरिगेशन प्रोजेक्ट बाकी सब समान कर दिए डिस्पोज कर दिए यस
Item 19.
appears for the apparent ତିନିଟା ଡେଟ୍ ହେଇଗଲା therefore କରାଉଛି matter today no one is representing so and so none appears on the apparent this is an argument today ହେଇଗଲା dismiss कर दो
So he is not interested. Apparently he is
ସବୁ ମାନଙ୍କର deal ଚାଲୁ साहब ଗୋଟେ ବିଆଇ को ସମାନ
second appeal. Second appeal.
second appeal মানে second appeal
It's a matter of reference.
Second appeal ବୋଧେ refer ହେଇଛି and the matter was listed by so and so as per order the matter was directed to place before so and so for constitution of
single bench.
non appeal police
So he is directed to place the matter for the annulment for constitution of fairness to municipality. So the municipality can be sued and sue and be sued without being represented by any person. মানে represented by executive officer বা কথা কি নেই yes entity
ତାଙ୍କୁ ଶୁଣିବାକୁ ତ
ହଁ
ଗୋଟେ କାମ କରନ୍ତୁ ମିଷ୍ଟର ନାୟକ ଗୋଟେ ସେକେଣ୍ଡ ଅପିଲ ଟେ ଫାଇଲ ହେଇଥିଲା ତା ଦେହରେ ଗୋଟେ ସେ ରେଫରେନ୍ସ ହେଇଛି one of the single judge refer kale matter chief justice हमको assign kale तबे matter टा होची justice बीबी रत्नकर माने से 2019-88 मसिया तबे से जो लोको appear करूनी ये लोको वर्तमान पंचीसी कि कौन हलानी ଆଉ ଟିକେ ଦେଖିନ୍ତୁ ସେ ଆଡ୍ରେସ୍ ଅଛି ଆମେ ଦେଇ ଦଉଛୁ ଆମେ ଆପଣଙ୍କୁ ଗୋଟେ ଏସେ ର ଗୋଟେ କପିଟେ ଦେଇ ଦଉଛୁ appeal memo ଟେ ତା ଦେହରେ ଯୋଉ petitioner को ଆପଣ communicate କରନ୍ତୁ ସେ ଅଛି କି ନାହିଁ to that IIC can get that instruction बरहमपुर टाउन रो जो IIC बुझिले से कहि देबे ଏବଂ ତାଙ୍କୁ communicate କରିଦେବେ ଯେ ଆସି ପଡୁ ସେ ଯଦି ନ ଆସି ତାପରେ we can pass appropriate order ହେଲା neither he is appearing nor anyone from the Barampur municipality also appearing ତେଣୁ ଦି ଜଣକୁ ଆପଣ ସେ ଲେଖନ୍ତୁ non appears for the either for the appellant or for the respondent on 2/12/2024 also on 6/1/2025 nobody appeared since it is a matter of the second appeal is of the year 1988, let a copy of the appeal memo be provided by the registry to the Land Council for the state, who in turn shall send the same to the inspector in charge of Barampur Town Police Station. And they are to communicate to the not only to the petitioner but also to the to the appellant Rajendra Patra, but also to the respondent Barampur municipality, that the matter will be taken up on 10th of February 2025. बाकी पूरा ऑब्जेक्ट काढ़ी भी दे दूं फोटो काढ़ी को क्लियर कर दे दूं कॉपी ऑफ द ऑर्डर कॉपी ऑफ the order will be handed over. Yes.
Item 20.
Please, my lord. My lord, here, no prayer for the amendment, we allow.
Pray for 1 week time to file objection. Last week only there's a copy.
Only prayer is simple in nature, sir. Simple in nature. Instead of taking that the order passed by the Central Administrative Tribunal to be set aside, that has been added in the amendment. If the prayer for amendment will allow, the main matter to be taken up in this week also, can be disposed of also. My lord, heard this matter at length, because due to vehement objection by the opposite party, I to file that amendment.
IA number so and so, this is an application for amendment filed by the petitioners, copy of which has already been served on the Land Council for the. You are appearing for which opposite
party 3.
Opposite party number 3. So you are also appearing for 1 and 2.
Sorry, 1 to 3.
1 to 3.
1 to 3.
1 to 3. Who will seek some time to file objection to the interim application. Next week, as well, formally, you would put up this matter on 27th of January 2025. Objection, if any, be filed. In the meantime, serving a copy on the Land Council for the petitioner. Yes.
Yes, obliged.
Item 21.
Yes, Mr. Kanandu.
Item 21. We are against an order of the DR80 Mallots. Mallots, what had happened during the procedure of auction? Mallots, I had participated in the auction, but I was not the H1, the present petition. Thereafter, Mallots, the auction was settled at 3 crore 35 lakhs. We made an offer of 4 crores. Now, we said that let this amount be taken and the plot be allotted in our name, conveyed in our name. We gave this amount of 4, we have deposited the draft option. Now, what happens? The DRT accepts our prayer. That let this amount be accepted because it's reasonably higher than 3 crore 35 lakhs. But the DR80 says as he had participated in the auction and as the auction has been concluded, so he has no further right to give an enhanced price. Now, my lords, my submission before your lordship is, if I am giving a substantially higher amount, 4 crores, my lords, is it not incumbent, because ultimately the bank is not a private money lender, my lords, is it not incumbent upon the bank to take the higher amount, my lords, which is substantially higher? I understand 3 crore 35 lakhs, I make an offer of 3 crore 40 lakhs. That I understand, my lords, the bank will not interfere.
You are appearing for the, Mr. Niyamati is appearing for 2 to 4.
My lords, Bank of Baroda, opposite party number 2, 3 and 4.
Right. And Mr. Sarangi is appearing for opposite party number 5. So, now this matter is ready. The pleadings are complete.
Yes, Your
My
Lord.
lord.
Because counter affidavit has been filed by the
By the bank.
2 and 4. And Mr. Sarangi, you are not filing any counter.
I have already filed.
You have filed. All right, you have filed.
Only an objection.
Objections also counter I have filed.
Counter we have not received. Counter.
No, it is mentioned, it is styled as objection.
Objection only.
ନାଇଁ ସାର୍ ଗୋଟେ ଅବଜେକ୍ସନ ଅଛି ଗୋଟେ କାଉଣ୍ଟର ଅଛି
Counter ନାହିଁ ଆମ ପାଖରେ
Counter
ନାହିଁ
ନାହିଁ।
ଆମ ପାଖରେ ନାହିଁ।
କେବେ ଫାଇଲ କଲେ କାଉଣ୍ଟର ଟାକୁ?
କାଉଣ୍ଟରଟା କାହିଁ
Counter means objection. My friend said not received the objection.
ନାଇଁ କାଉଣ୍ଟର affidavit has been filed on my lords 8/8 8/1
ସେଗୁଡା ପୁରା ଅବଜେକ୍ସନ ଲେଖା ହେଇଛି ସେଗୁଡା କହୁଛ। Is it ଯୋଉଟା ଲେଖା ହେଇଛି
ଅବଜେକ୍ସନ ସାର୍ ଗୋଟେ ହେଇଛି ଆଏ ରେ
ହଁ ସେ ଆଇଏ ରେ ହେଇଛି।
ଆଉ ଗୋଟେ ହେଇଛି
That is on 7th of January.
ଏଠି ଉପରେ ଅଛି 8
ହଁ 8 ରେ sealing।
ଏଇ ଯୋଉ ଅବଜେକ୍ସନ ଟା ଆପଣଙ୍କର ଅଛି ଏଟା ଆଇଏ ରେ ଅଛି। ଆପଣ ମେନ୍ ରେ କିଛି ଫାଇଲ କରିଛନ୍ତି କି?
ହଁ ସାର୍ 13979 of 24 କେସ୍ ନମ୍ବର ଦେଇକି ମୁଁ କରିଛି।
Counter affidavit on behalf of the opposite party number 2, 3 and 4.
I see 5
Year for 5.
କେବେ ଡେଟ୍ ଟା କୋଉଟା ଆମେ ରେଜିଷ୍ଟର ମଗେଇବୁ?
ସାର୍ ଏତେ କଥା କାଇଁ ଆଉ ଗୋଟେ କପି ସବ୍ କୁ ପିଟିସନ କହୁଥିଲା
ଆରେ ଆମର ଏଇଠି ବି ତ ନାହିଁ ନା।
ଏଠି ନାହିଁ
ଏଟା କାଉଣ୍ଟର affidavit
Counter affidavit.
କେବେ ଫାଇଲ କରିଛନ୍ତି ଡେଟ୍ ନାହିଁ ଅଛି
ଡେଟ୍ ସାର୍ 8
I will bring it to order on the same day.
that must be placed on record ତ ଆପଣ ଅବିକା ବଢେଇଲେ କଣ?
ନାଇଁ ନାଇଁ I will file another copy, that's what I am saying.
Page
କେତେ? 86.
କାଉଣ୍ଟର affidavit ଲେଖା ହେଇଛି ସାର୍
just
ରିସିପ୍ଟ ରେ ଗୋଟେରେ ଅବଜେକ୍ସନ ଲେଖା ହେଇଛି
କଣ
ଗୋଟେରେ କାଉଣ୍ଟର affidavit ଲେଖା ହେଇଛି
କହୁଛି
ନମ୍ବରଟା ଭୁଲ ହେଇଛି
Opposite party number 2, 3, 4 ପରା is fine. I don't understand.
ନାଇଁ ନାଇଁ 2 3 4 ଦେଖି ପାରୁନି।
This is counter affidavit by 5.
I want counter
I request the court master to look into my receipt. ପାଇଲେ
Counter affidavit by 5.
ବାହାର କର ସେଟା
113 page.
ଆମକୁ ପେଜ ମଧ୍ୟ ରିକନସାଇଲ୍ କରିବାକୁ ପଡିବ
just a minute. Right, that is there. So Mr. Niyamati,
My lord.
so have you received the counter affidavit which has been filed by OP5?
No, my lord, I have not received.
And Mr. Kanungu, have you filed?
No, we
You have not received.
We have received the objection. We have not received.
No, that counter affidavit.
No, counter affidavit.
So give it. You have handed over to.
I will serve another.
And ଲେଖନ୍ତୁ ଆମେ ଲେଖୁଛୁ ଯେ ଆପଣ କାଲି ଭିତରେ ଦେଇଦେବେ।
ହଁ ସାର୍ ମତେ ନିୟାମତି ଓ ତାଙ୍କ ଅବଜେକ୍ସନ ଟା ଦେଇନାହାନ୍ତି
ଦିଅନ୍ତୁ।
I will sir, ma'am. I will sir. ମୁଁ WhatsApp ରେ ପଠେଇ ଦେଇଥିଲି ଆପଣଙ୍କୁ ତେବେ ବି again I will give a hard copy.
Delete ହେଇଯାଇଥିବ
ଆଉ ଗୋଟେ ଦେଇ
ଏଟା ବେଶୀ WhatsApp ୟୁଜ କଲେ delete ହେଇଯିବ।
ସାର୍ ୟୁଜ ହଉନି ବୋଲି
ଆଚ୍ଛା ହଉ
ଦେଖିନି
My lord, let it be listed along with another another writ petition that is similar 13529 of 2024.
13529.
My lord.
529 of
2024.
The original borrower had also challenged. My lord, he has withdrawn in the meantime. 42086.
Just a minute. Mr. Kanungo, Learning Council appearing for the petitioner, senior advocate. So also Mr. Niyamati, Learning Council, who is appearing for the opposite party number 2 to 4, submitted that they have not received the counter affidavit filed by the opposite party number 5. Mr. Sarangi, senior advocate, submits that by tomorrow we will hand over the counter affidavit copy to not only to Mr. Kanungo, so also Mr. Niyamati, and Mr. Niyamati submits. ଆପଣ କଣ ପାଇନାହାନ୍ତି କହୁଛନ୍ତି?
No, the objection filed by the opposite party number 5.
Submit that he has not received the copy of the objection filed by the opposite party number 5, IN number 12945 of 2025. Let Mr. Sarangi and senior advocate also supply the copy of the objection to the said IA to the Mr. Niyamati by tomorrow. Place this matter on 27th of January. आपको अधिया समय दरकारी काउंटर फाइल कला पर किसी रिजोइंडर करे देबा कि दरकारी ना देखिला पर डिसाइड करी
7th ना first week of February.
first week ताले 3 तारीख रखी दोशी जदी किसी रिजोइंडर फाइल करे था करिवे और तब put up this matter on 3rd February 2025. If any the Land Council for the petitioner, if so likes, can file the rejoinder affidavit. Also, put up, giving copy to the Land Council for this one. Yes, next.
मते उडे कॉपी देबे नियमति हो सर
Lordship, may I please status को as on date be mentioned?
5 वर्ष वाला मु देलिनी पोजीशन
Possession.
देइची काम रिप्लाई देइची
स्टेटस कोई बिल तो सी रहिबो जदी
हाँ हाँ मुझे राइट
स्टेटस को सर 5 वर्ष वाला मु देलिनी पोजीशन अब ये जो कहिले सर दैट ही ऑफर 4 करोड़ 4 करोड़ से ऑफर सेतबे करना ही वाज ब्रॉट इन
रीडिंग कंप्लीट हेलानी हम सार दबा एते कथा कोन 3 तारीख रे
It's be listed along with the other writ petitions.
अच्छा लेखुन मिस्टर नियमति सबमिट्स द एटा कोन सेम
My lord, same order has been challenged.
नियमति सबमिट्स
WPC 13529 of 2024.
which is connected to the present petition, that is WPC number 13529 of 2024.
And my lords, WPC number 42086 of 2023.
086.
My lords, 42086 of 2023.
Where is your writ petition filed in 2023? Are you sure that it is 42086?
86. Yes, my lord, the order sheet is there. Order sheet is in front of 42086.
86 of 20.
My lords, 23.
Botella 1 3 5 2 9 2024 out of 4 2 0 8 6 2023 डेट रेगुलर 3 तारीख है ना
এটা স্যার ডিসপোজ অফ এই 42086 টা
যা আসিব আর ঠিক কো Yes, next.
3 টা স্যার মানডে
কোটা গেল
3 তারিখ
4 তারিখ মন্ডে আসিব
4 তারিখ
4 তারিখ কোচিন হবে এটা 4 রে করতে 4th of February 2025. Yes.
So, but item 38 also, always coming up, it's not reaching. Only the state has to file a counter. They are not filing a counter. Just for a reach we code, it's being time is being taken.
Item 38.
Again. Let them file a counter in the meanwhile.
Just.
You have received the paragraph comment.
Item number 38. Are Mr. Milan Kanungul and senior advocate for the petitioner. The Land Council for the state submits that Parwise comments have already been received and the counter affidavit will be filed within a period of 2 weeks. No. Okay. Put up this matter. 3 weeks for them. Please this matter will come in on 17th February 2024. All right. Copy of the counter affidavit be handed over to the Land Council for the petitioner. Yes.
So that's interim orders.
Interim order to continue till next.
Yes.
Item 22.
May I please, can I have a glance to the last order, my lord?
Instruction.
Yes, my lord. Last order, my lord, is passed. We have already received instruction. Let's give 10 days time to file counter. Already we have received the instruction. In that instruction, it was they have mentioned that the pipeline is taken in their plot number 2068 and 1640. They want modified the same. In that regard, we have filed the counter, madam. Let's keep it updated.
So, Pari, we have observed in the order dated 2/1/2025 that no instruction is received in OP number 2.
Madam, already we have received the instruction. We have received the instruction.
So you can do it during course of this week.
Yes, we'll try to do it in course of this.
Learned counsel for the Mr. Pari, learning Deputy Solicitor General, appearing for the opposite party, along with Mr. D. Gochai, learned Central Government Advocate. Council submits that instruction has already been received, Mr. Pari.
Yes, my lord. Instruction received. Yes.
And the counter affidavit is to be filed within a week. This matter in the week commencing from 3rd February 2025. Yes.
Who will it?
Mr. Guru is present for the land council for the petitioner is present. Yes. Section upon notice.
No, original order is not in the record.
The same is to be prepared. Yes. Reconstitute. I'll be जो original जो का download order है 10 ना दे आप रेफर हम 10 का नहीं दे yes
Item 23.
Already received the instruction, but I
2025. I have filed an amendment petition, including 2% as to party one.
which order
2/1/2025.
today they filed the IA. Let's give some time. Then
To implement this 2%.
today they just file the IA today and copy served on today also itself. We received the copy on IA today.
Okay. Mr. Paril and counsel for the Deputy Solicitor General submit that he has received the copy of the interim application which has been filed for amendment to insert the names of respondents as opposite parties.
As 6 and 7.
As opposite 6 and 7.
6 and 7.
Yes.
Then counsel for the submit that week's time may be granted for filing objection, if any, to the interim application. Clear this matter. We commencing from 10th of February 2025. Objection, if any, to the IA be filed in the meantime. Yes.
Item 24.
Pardon, my lord. On virtual mode, I am submitting, my lord.
Yeah.
Earlier, my lord, I am submitting the copy of the honorable court order after the 3 months, my lord. Let the order may be passed, my lord. I file the copy of the order in fresh match. On 4/1/2025, I am submitting by the post, my lord. Difficult to the petitioner is a lady and ill, so not attend to the office of the secretary building to submitting the application in meantime within 3 months, my lord.
Type and the direction.
Opposite party number.
Just a minute. This petition is disposed of directing the secretary so and so to consider the representation in accordance with one report of the same within a period from the date of production of the certified copy of the order. So, कौन है आपने certified copy देई ना दी?
I am submitting the certified copy on 4/1/2025, my lord. Before that, they have submitting they have issued the letter on 23rd December 2024. I am not submitting the application within 3 months, my lord. I am submitting the application before the opposite party number 4, Lord Tahsildar, but not submitting the application in person before the opposite party number 2 in the office of the secretary building, Home Department. So my kindly fresh the application. I sent the application through the postal manner, not personally submitting the application.
Not application, certified copy of the order.
My lord, certified copy of the order I have submitting on 4/1/2025, my lord.
Just a minute, Planning Council. The order is very clear. The order थिला जे आमे कहि नथिलु जे केबे आपण प्रोड्यूस करिवे आमे आप कहिथिलु जे आपण जेबे प्रोड्यूस करिवे ଅର୍ଡରଟା ସେବେଠୁ 3 ମାସ ଭିତରେ ସିଏ ତାକୁ ଡିସ୍ପୋଜ ଅଫ୍ କରିବେ, ଡିସ୍ପୋଜ ଅଫ୍ କରିକିନି ତାର 15 ଦିନ ଭିତରେ କୌଣସି ଅର୍ଡରଟା ପାସ୍ କଲେ ତାକୁ କମ୍ୟୁନିକେଟ କରିବେ। ଆମେ କହିନଥିଲୁ ଯେ ସାର୍ଟିଫାଇଡ କପିଟା କେବେ ପ୍ରଡ୍ୟୁସ କରିବେ। ସାର୍ଟିଫାଇଡ କପି ଏବେ ପ୍ରଡ୍ୟୁସ କରିବେ, ସେ ତା 3 ମାସ ନେବେ ଆଉ କଣ, ଏଟା ଆପଣଙ୍କ ଉପରେ ଆମେ ତ କହିନୁ ଯେ ଆଉ ଏକ୍ସଟେନସନ ପାଇଁ କଣ ଆସିଛନ୍ତି।
Obliged, my lord. On 23rd December 2024, my lord, they have issued a notice bearing number 4824 of 48, 23rd December 24. They have issued a letter that the petitioner has not submitting the certified copy of the honorable court, so it is disposed of.
Oh, dispose of कर दीजिए।
My lord, on that ground, my lord.
कहीं से ये कहीं?
My lord, and this is the order to me, my lord. I am submitting with a memo, so I am in virtual mode, my lord. So, my lord, after in the course of the day, my lord, I am submitting the application.
So if they have already disposed of your representation
on the ground, my lord, that I am submitting the certified copy of court order.
So that order is to be set aside then for fresh consideration of the representation. You have to file a fresh writ petition. If your representation has already been disposed of and whatever reason may be there, and you are to file a fresh writ challenging the same, and another opportunity may be given.
My lord, may kindly, this matter has been already on process in the office of the opposite part number 4 Tahsildar. So in that meantime,
no, because that disposal order or of your representation is also not before us, and you have simply filed the IA to extend the time to furnish the certified copy. That's all here.
my lord, may kindly adjourn tomorrow, my lord, I will submit the copy of the letter
for the petitioner 6 for an adjournment. This matter in the week commencing from 27 तारीख रे रहला 2025.
Item 25.
25 में lordship, it has come up delay for in the order pass inadvertent to the
correction कर दो लिखूं भी order dated 8/1/24 है IN number तक हम लोग भूल ही type shield 101 okay लिखूं भी the office has pointed out that in the order number 2 dated 8/1/2025, the IN number has been incorrectly reflected. Stop. Let the IN number 10190/2024 as mentioned in order number 2 shall be read as IN number 16190 of 2024. है ना? तापरे हाँ कौन कहउछंती आपण काउंटर एफिडेविट फाइल करना हंती listed on 8/1 Land Council for the state seeks some further time to parawise comment receive कर जन करना है तर देरी हो some more time to file the counter affidavit. So let us to February 17 तारीख February 27 2025 है ना
may I make a submission? I have already obtained the certified copy. Order. Here the IA is mentioned 10190. Can it be correct?
The Land Council for the petitioner submits that he has obtained the certified copy of the order number 1 and 2, and the correction may be carried out in the certified copy. है ना? ताकू से ये टाकू correct सुनो एटाकू आनिबो correction करिकिनी signature करी seal मार दे छाड़ो है ना so that is
shall I give it over here?
Yes, no, you give it here. एटा करिकिनी हम hand over कर दो ये बोल से number टाकू ନାଲିରେ କାଟିବ, ନମ୍ବର କରେକ୍ସନ କରିବ, ତମ ସିଗ୍ନେଚର କରିବ, ଡେଟ୍ କରିବ, ସିଲ୍ଟା ମାରି ଦେଇବ ହେଲା। ୟେସ୍ ନେକ୍ସଟ।
Item 26.
Correction of the title of the
ନାଁଟା ଭୁଲି ଯାଇଛି।
ଆଜ୍ଞା ଏଟା SINGH ହେଇଯାଇଛି
ସେଟା ସିଂଟା G SIMGA G ଖାଲି ରହିବ, GS ହେଇଯାଇଛି। ହଉ ଦେଖନ୍ତୁ the officers pointed out that in the first title of the order number 1 dated 8/1/2025. 8/1/2025, right? The name of the petitioner number 1 has been incorrectly reflected as so-and-so in place of so-and-so. Let upon certified के भी नीचे नहीं। अच्छा। Let the same be corrected as so-and-so, है ना? And in the certified copy which is obtained by the learned counsel for the petitioner, the same may be carried out, है ना? You give the certified copy, and if certified copy टा देले correction के लिए अपने hand over करिए। नहीं, अच्छा जेबे देबे आनी को। Alright, next. That's fine. Yes, sir.
Item 27.
In fact, item 27, my lord, I sought for review the order date 2/9/2024, but they are delayed up around 3 months there.
Delay कितने देखे जाएंगे?
3 months.
Reporting 98. अच्छा।
He said
Notice is waging.
my lord, my lord. So far the prayer is concerned that all right. So far the first para of the petition also that is also
Delay टा कौन होगा क्या? Let's go. IE number.
one more thing bring it not para 1 of the review petition वाला। Original जो read the challenge करते जो original order passed by the collector बोला that is wrongly reflected. So it will be
both rate.
Review petition page 2 para 1 रे।
हाँ।
जो collector जो original order pass करते 5/10/2023 रे that part I have reflected because
कौन आप correction करिए कि review petition में?
The correct enter first para चाहिए। It will better my lord permit me to withdraw with liberty to.
Alright, the learned counsel for the file memo.
Yes, my lord.
Learned counsel for the petitioner files a memo to withdraw the review petition. Memo is taken on record.
The original copy we substituting the
review petition is disposed of as we withdrawn, giving liberty to the petitioner to file so-and-so. The certified copy of the order dated so-and-so be handed over to the learned counsel for the petitioner on being substituted with the Xerox copy. Yes.
Item 28.
Wait. Just 2 minutes. Within 2 minutes.
My lord, in this matter, my lord, Your
Item
Lordship,
28.
My lord, item 28, in this matter, an advocate general will appear and the adjournment from other date.
my lord, 4th of November, Your Lordships have asked my lords for some instructions, but if he's in a difficulty, I can't object.
Mr.
Lordships may then have it, my lords, 3rd of March, if possible.
Just a minute. We are going through the order dated 25/9/24.
Please, my lord. Paragraph 4, my lord. But also, subject to your lordship's pleasure, this is a consent, my lords, which the court had thought, which is reflected in the order dated 1st of March, 24, paragraph 4 again.
So the just Mr. Naik, the learning advocate general has to obtain inspection whether there is any chance of settlement that has been reflected in that order dated 25/9/2020. So if the answer would be no, then the matter would be hard on merit. But for that, the order was passed and more than 3 months have already passed. So this much of information is to be.
My lord, kindly day after tomorrow, I'll apprise my lord. My lord, okay.
But there is a slight catch in this, if your lordships will permit me. But if your lordship sees 1st of March 24, after that, my lords, pursuant to that, the parties have sat together. Now, after sitting together, there was some progress. We moved, my lords, but that was before the predecessor of the learned advocate.
That is
Yes. Now, my lords, we had moved, and it was a very constructive meeting. But now the new advocate general has taken over. So, my lords, I had submitted that to carry that consistency forward, whichever way it goes. It may be yes, it may be no. But there's a process which has been initiated by the AGs of the Honorable Court. But that process.
Okay. He wants it next just day after tomorrow.
No, I'm saying something else, my lord. Your lordships may just bear with me. So that process, my lords, entails that we sit and we show that this is the plan, this is the site, this is the fact, this is the land available. Unless and until mind is applied, my lords, it will be a very abrupt.
Let them.
But then, Mr. Sharma, the AG should agree to that. The government should have a policy for that.
My lord, this is no, that's right, my lords. I completely bow down. That is why, my lords, the previous advocate general had summoned a meeting. We had all sat together. There were 5 officers from the other side. 15 people attended that meeting. It went on for 1 hour.
Okay. As paid for by the Land Council for the state, placed this matter on 22nd of January 2025. Mr. Sharma, Land Senior Advocate for the petitioner is present. Mr. Ashok Manti, Land Senior Advocate for opposite party number 4 is present. Mr. S.K. Land Senior Advocate for opposite party.
I am present. S. Nanda.
Mr. S. Nanda, Land Advocate for the have been also designated.
Yes, Mr. Senior Counsel is not there. So, I am okay.
All right. So is you are for opposite party number 5. 5 is present. All right. 22nd of January 2020. All right.
Item 29.
29. This is order dated 9/12/24. The PIM. para 6 of the order.
912.
Again. 9,
Where is Mr. Mohanty?
On behalf of Mr.
9/12/2024.
Para 6 of that order.
Right. CAG report.
Sir, placing the report on memo. I have received point-wise compliance day before yesterday evening on what they have done with this. Kindly grant me 2 weeks time to examine and I will present. Sir.
We asked the running counsel for the state to produce the CAG report and also obtain instruction whether any such report was placed before the state assembly, and if so, whether any action was decided to be taken there.
The report I am placing, it has been placed before the assembly, it was debated. Subsequently, they have given some point-wise compliance based on that report. That compliance I have received before yesterday evening. I have to examine that compliance and I will comply.
All right, in portions of the order dated 9/12/2024, the Land Council for the state has produced the CAG report.
It's the extract, it's a long report.
That's the extract of the report of the Comptroller and Auditor General of India.
The relevant portion.
Relevant portion.
The relevant portion of this one, which is with a memo which is taken on record. He submits that so far as action taken on the aforesaid report is concerned, he has received the parawise comments,
Point-wise compliance.
point-wise compliance, and he may be given some time to file an affidavit in that. File an affidavit. So let it come after 2 weeks. This matter in the week commencing from 10th of February 2025.
Okay.
Later on. Yes.
Item 30.
Item 30, as per manual direction dated 18/12/2024, the OP number 4 filed the affidavit on 13/1/2025. That has not come to the record.
From the government that he has received the written instruction, the matter cannot be settled and wants to file the same with an affidavit form.
It was fine. Well, it was fine.
You have received the copy?
I have received the copy, my lord. Here, the opposite party number 4, they have filed the affidavit. In fact, order dated 21/8/24, it was submitted by the state to explore whether it is settlement is there possible or not. Even on 11/9/24, it was suggested to sit together. Now, this open number 4, who is the beneficiary presently illegally has been allotted in land. In para 7. Illegally allotted, the lease was expired on 1976, my lord. After 17 years, the petitioner filed application for renewal of the lease, my lord. By then, many things changes, my lord. So pleadings are there. Pleadings are already complete. In para 8, they say it is humbly something the opposite party number 4 has no authority to settle with the petitioner. They are incompetent. They cannot settle.
Just a minute. What we find that in the noting in the cause list, it is mentioned that counter affidavit by opposite party number 2 and 4 is there. Then rejoinder by the petitioner to the counter so and so, that is also there. Reply affidavit to the rejoinder is there. Affidavit in reply to the affidavit dated so and so, copy not some. For the rejoinder affidavit so and so. So what you have filed?
My lord, the opposite party number 4 filed the affidavit that he has no authority to settle with the petitioner because the opposite party number 4 is the tourism department, my lord. Land was originally belongs to revenue department. In case what happened, my lord, in 1916, the land was allotted, leased out in favor of one person, my lord. That for a period of 30 years. Then it was renewed for again for a period of 30 years.
within that 30 years, their original lessee, he sold the land to the present petitioner. After the lease was expired in 1976. After expiry of the lease, the land was recorded in the Anavadi Khata. Then when the revenue department alienated the property in favor of tourism department.
Resumed it and released.
And tourism department, one construction was also developed, one food court was constructed. In the year 93, the petitioner filed an application for renewal of his lease. That was rejected, my lord. Now, many things changes, my lord. On the ground of only delay, this writ application should be dismissed, my lord.
Okay, no, that is on merit. What? Why are you asking for time?
No, I am not asking for time, my lord. The affidavit already filed, that has not come to the record.
What affidavit?
That it is not
affidavit pursuant to order dated
18/12/2024.
So that the matter cannot be settled.
Settled, my lord.
So,
All right.
that the collector should have filed, my lord. Because this in POP number 4, they are saying in para 8, opposite party has no authority to settle. In fact, they don't have the authority to settle. They are tourism department.
No, we do not know what is they are mentioned in that affidavit. Let it be brought on record. We will see that. The Learned Council for the state submits that as per order dated 18/12/2024.
Well,
affidavit has been filed by opposite party number 4, and copy of the same has been served on the Learned Council for the petition. The affidavit be placed on record, matter be listed on 27th of January 2025.
In fact, there was a direction to file whether it is going to be settled or not. So they have created certain more additional files. So in that event, in that event, we may be required to file, if it is taken as a pleading, we will be required to file counter.
Let it come on record, then you can file.
Or if it is limited to honorable court's compliance with the order, then I will not be required to file further affidavit.
See, yes, and it is to come with contempt application number so and so 17 of 2022.
Entry model to continue.
Entry model is there. Entry model to continue.
Item 31.
Mr. Kanungo.
31. Your lordships have encapsulated the entire case by order dated 14/11/24. Lordships may kindly see order number 9 dated 14/11/24. From paragraph 4, it is a contention that the original lessee of the land in question, situated in village Dalua, was one Sridhar Majhi, whose wife sold the land to one Rashmi Rai with due permission by executing registered sale deed, and the petitioner, who is a Navy personnel and captain in Indian Merchant Navy, purchased the land from the said Rashmi Rai. Initially, when the ADM, Khurda and Lease Revision Case number 107 of 1988, Wide order dated 31/3/1988 in exercise of the power under Section 7A of the Orissa Government Land Settlement Act 62, cancelled the lease granted in favor of the original lessee. The present petitioner challenged the order of the ADM before this court in WPC number 14429 of 2006 and wide order dated 14/11/2006. A division bench of this court has been pleased to quash the order passed by the learned ADM Khurda dated 31/3/98 in lease revision case number 107 of 98. Further submitted that the said order passed by this court has not been challenged by the state, and that is how the same has attended finality. However, in the impugned order, the ADM, taking into account the resumption of the land to government khata which was done earlier and set aside by this court in the aforesaid writ petition, has refused the prayer made by the petitioner to record his name in the ROR, which is not proper and justified. When this court made a query as to whether he is having the original lease deed with him, learned counsel pointed out that the order sheet of the order of the Tahsildar Bhubaneswar dated 10/6/2014 in WL case number 23 of 2013 indicates that the DA lease has submitted original lease number 771 of 72 attached to the case record. At this stage, the learned counsel for the state seeks some time to produce the case record of WL Miss Case number 23 of 2013. In view of the submission made by the learned counsel for the state, lists this matter on 26/11/24. Thereafter, 2 dates have passed, and your lordships have also directed as a last chance, but they are not getting the original case.
My lord, I have received the instruction that the Tahsildar has issued a letter that the WL Miss Case number 23 of 2013, it is submitted that the same is not traceable, readily traceable in the record room. However, sincere steps are being taken to trace out and submit the same at the shortest possible time. This is on 3/12/2024.
Shortest time to galaani.
My lord.
How kitne shortest to?
This letter was but it was submitted to the office of AG on 19/12/2024.
He is relying on that. The Tahsildar is relying on the order.
Notification number 1879. Dated 5/8/2011.
Was subsequently set aside by this honorable court. So if that goes, my lords, and the order reaches finality, he cannot act upon the previous order and say that the lands have gone to the government khata. That order has
So
been
the
set
question
aside.
is, Mr.
Yes,
President, that
original
original lease
WL
deed, how did you submit the original lease deed there?
My lords,
Why you submitted it? It should have been kept with you. Why it was submitted before the Tahsildar? Has he asked for the original lease deed to be submitted? Ordinarily, it is verified and
my lords,
you
this
file
has
a
been
Xerox
verified by the officer who has granted the permission because this was an ST land earlier. Original lease deed was a subsequently. Semane produced for Ame actually did. They had produced the original lease deed. Our vendor. Amupatra, we have only one sale deed with and the permission, of course, from Rashmi Roy. Rashmi Roy produced the original sale deed, lease deed and this.
In fact, that is how we sought for that.
Yes.
Because
My lord,
original
in
is
this
not
case,
seen
what-
anywhere.
My lord, in this case, what happened after the lease was cancelled? Thereafter, the sale deed was executed.
No. That's not a fact. Sale deed was, lease deed was never cancelled. Sale deed was in 1990. 98 where there was a cancellation which has been now set aside by this order.
But it was cancelled in 98.
1998.
1998.
Yes.
But the RSD was in 1990, first RSD.
Yes. First RSD means
No, 88 and next was in 1990. So
Yes.
your RSD was in 1990, much prior to the cancellation.
Yes, much prior to the cancellation. And this we challenged before your lordships. A division bench of this order.
Which has not been challenged.
So that order attains finality.
That attains finality, but for our purpose, we wanted to see what was the condition in the original lease. That is why, where is that? WL is what?
transfer
What my London friend is saying, I have also seen some other lease deeds. There is a gap of 10 years. Amara 16 years for a transfer. 16 ବର୍ଷ ପରେ and ସେଟା ନିଶ୍ଚିତ notice ହେଇଥିବ ଆଜ୍ଞା because the authority who grants permission to the ST the original vendor, the original owner was
Jawan.
Was Sridhar Maji. So he was an ST person. So while granting permission, they must have gone through the entire lease deed given to Sridhar Maji and found out whether such a condition exists somehow. After getting due permission, this was transferred to Rashmi Roy. And Rashmi Roy became my vendor.
Paragraph 4 of the counter affidavit filed by the Tahsildar, my lord, I have a glance. government land to an extent area
ଟିକେ ରୁହନ୍ତୁ ଯୋଉଟା ଅପୋଜିଟ୍ ପାର୍ଟି ନମ୍ବର 1 and 2
ମାଇଲା
ପ୍ରିଲିମିନାରୀ କାଉଣ୍ଟର ଆଫିଡେଭିଟ୍
ମାଇଲା
ହଁ କୋଉ ପାରାଗ୍ରାଫ କହୁଛନ୍ତି
paragraph 4
କପି ଦେଇଛନ୍ତି
yes
ହଁ କଣ the brief fact of the case
my lord
ହଁ ପଢନ୍ତୁ
government land the brief fact of the case is that government land to the extent and area of 0.750 decimal isam so and so was leased out in favor of one Sridhar Machi, son of so and so, by the order of the Tahsildar Bhubaneswar in WL case number so and so for agriculture purpose. Later, the lessee got mutated ROR by khata number so and so, measuring area so and so. The present petitioner, the subsequent purchase of the said land in question by RSD number so and so dated 9/5/90. Thereafter, a lease revision case bearing number so and so was instituted suo motu by the additional district magistrate Khordha under section 7.
Then he is right what Mr. Kanungo is saying that first the RSD was done, then this
lease
was
was
cancelled.
The
which was set aside. The
Which was
ADM's
set
order has
ADM
been set.
disposed lease revision case numbers on 31/3/1998. Cancel the sanction of lease had double case number etika since the settlement of land by the Tahsildar suffers the legal infirmities and material irregularities.
That is why we want to see the original lease.
Yes, my lord.
Or else there is no scope because it is all challenged and it has reached the finality having not challenged, which has been set aside.
My lord.
ଆଉ କିଛି ଆଉ ଅନ୍ୟ କିଛି ନୁହେଁ.
Original double case number 771 of 72.
Right.
So where is that cancellation order or the
ADM's order?
ADM's order?
ADM's order was already.
ADM order.
That is 2006, no? No.
ସେଇ ଗ୍ରାଉଣ୍ଡ ରେ ହିଁ କରୁଛନ୍ତି ଯାହାଟା ଲେଖା ହେଇଛି ଯୋଉ
The order same ground has been reiterated. The present order
So this suo motu revision was to be undertaken within 14 years as per this statute, which has been taken up after 4 years. That is how the court has set aside.
No, after this division bench order was passed in WPC number 14429 of 2006 in 2014 1/11/2006. So on what basis this was cancelled by the in 2009 or something like the ADM you have passed for the order time.
My lord, thereafter, my lord, the petitioner filed an application on 26/2/2013 before the Tahsildar Bhubaneswar praying for correction of ROR in favor of in compliance to order of Honorable Court dated 13/11/2006. Tahsildar Bhubaneswar receipt of the application initiated lease miscase number 23 of 2013 and processed as per the provision of law. Then due to delay in disposal, then another writ application was filed. For non-compliance, when contempt was also filed. Thereafter, the Tahsildar took up lease miscase number 23 of 2013 and issued notice to petitioner twice through registered post, and also notice was served through postcard as well as process server. As ascertained, R.I. Mendhasala inquired into the matter, reported that the land has not been used for purpose for which the land was leased out, that is agricultural purpose. The land presently barren, neither anybody is cultivating nor any structure, boundary wall constructed over over it, and the lessee or the present petitioner is not in peaceful possession of the land. This is the RI report. The petitioner also did not participate in the that WL miscase matter. That is reflected in the order sheet. The additional Tahsildar, taking into account the aforesaid report of RI, rejected the prayer of petitioner for correction of the ROR in his favor.
So the basis on which the additional Tahsildar has rejected it, having once setting aside the order of the ADM on the ground that the suo motu
Suo motu
cannot be
can-
resumed
My lord,
after 14 years.
my lord,
Is this order proper by the Tahsildar?
my lord. The Tahsildar rejected on the ground that the petitioner did not participated in the.
So you mean to say that this is a new cause of action?
Yes, my lord.
How do you, it goes against the division bench order of this court?
No, division bench set aside the suo motu order passed in the suo motu.
ADM
Yes.
record.
So that the previous order stands.
Stands, my lord.
Then
The petitioner filed application for correction of the ROR.
yes, you should have done it.
It was rejected because it was not in possession. Nobody was in.
Mr. Unless the division bench order of this court passed in that 2006 WPC is set aside, then you cannot deny the
So
mutation.
he is saying that yes, that means you mean to say that the order of this court was purely on the point of law because it was not taken up within 14 years.
My lord.
It was not on this ground and you have taken a second ground.
Second.
Oh, if it cannot be done directly, has been done indirectly. Yeah, right. So it's a mutation proceeding giving rise to a cause of action to the Tahsildar to independently take up the matter.
My lord.
This to sit in appeal over the order of the ADM, over the order of the High Court.
All right. We are giving you a last chance, otherwise we will finally hear this matter and dispose of it. The Learned Counsel for the state submits that he has received the communication from.
That land is.
No, don't argue on merit.
We'll see. We'll see.
That he has received the communication. Card communication. Tahsildar Bhubaneswar, that some more time you require now. Some more time is required to trace out the WL miscase number
771 of 2000.
Case records of WL miscase number 23 of 2013.
ସେଥିରେ ଅଛି 771 of 72 ବୋଲି କହୁଛନ୍ତି।
ହଁ, ଯୋଉଟା କି original lease date ଟା ତାର ଦେଇ 23 of 2013. Put up this matter on the 10th of February 2020.
My lord, along with the original lease number 771 of 72 time.
ସେଟା କହୁଛନ୍ତି ତା ଦେହରେ ଦାଖଲ କରିଛନ୍ତି ଆସିଲେ ଯଦି ନଥିବ ତାହେଲେ ତାଙ୍କ ସବମିଶନ ଯୋଉଟା ଠିକ ନୁହେଁ ବୋଲି ଆମେ ଧରି ଯଦି ଫାଇଲ କରିଥିବେ ନିଶ୍ଚୟ ଗୋଟେ ଅର୍ଡର ସିଟ୍ ମେଣ୍ଟେନ ହେଉଥିବ ଅର୍ଡର ସିଟ୍ ରେ ଲେଖା ହେଇଥିବ ଯେ on such and such date he filed the original lease date it is taken on record तो ଜଣା ପଡିବ ଅର୍ଡର ସିଟ୍ ନା
सर ଆମେ ସେଟା ଫାଇଲ କରୁ
गवर्नमेंट ଆସିଛି ତା ତରଫରୁ
गवर्नमेंट ତା ତରଫରୁ ଲିଷ୍ଟ ରିପୋର୍ଟ ଆଣିଥିଲା 39 the order is case record is put up today petitioner is present and filed Hazira the DA lease case has
ସେଟା ଲେଖା ହେଇଥିଲା that is mentioned there
original lease number attached with this case record এটা ହେଲା order dated sir 10/6/2014
ତେଣୁ ଅର୍ଡର ସିଟ୍ ରେ ଆପଣଙ୍କର ଯିଏ ବି ଡିଲିଂ ଆସିଷ୍ଟାଣ୍ଟ ସେ ଲେଖୁଛି ଯେ ଏଇଟା ପ୍ରଡ୍ୟୁସ ହେଇଛି ବୋଲି ତେଣୁ ୟୁ କ୍ୟାନଟ୍ ସେ ଦ୍ୟାଟ୍ नो ଇଟ୍ ଇଜ ନଟ୍ ଆଭେଲେବଲ ତେଣୁ so on that basis if you do not produce then it is to be presumed on the basis of the order that such a lease deed was in existence and
so that lease deed there is no dispute regarding that but he only says in this impugned order he only says that because the lands have gone to the government khata I cannot mutate it in your favor that's all he says at page 49 sorry 45 44 start hochi 45 land has already been resumed to government khata as per legal material irregularity and legal infirmities noticed by the ADM Khurda. So he is relying on that order again of Khurda ADM.
10 to 2025.
In lease revision case number 107 of 98, in this instant case, it is found that the land is fallen barren. Present this petitioner or the lessee is not in peaceful possession of the suit land. pertinent to mention here that the original lessee, being aware of the legal status of the leasehold land, has never challenged the order of the revisional authority.
Yes, that is
rather
how we
this-
say whether this will be a new cause of action merely because the party is coming for mutating its name
Yes.
in error, or it's a order which is which has been repeated.
Well,
So it will come on 10/2/2025. So rest of the matter tally registered.
लॉर्डशिप से एथरे 1/11/2024 रे बेल ले जाइछि तार सरेंडर करबो 1/2/2025 रे
Report has come.
Submitted by the land session judge from Special Judge Malkangiri. That will be listed on 10th of February 2025. Since the date of surrender, the appellant is fixed to 1/2/2025 in the land trial. After surrender of the appellant, the land trial court will submit a report to this court to reach on or before 6th of February 2025. Copy of this order be communicated to the land trial. Yes.
Item 2.
please do also. Hello, in this case, the prisoner filed the early for infringement on the ground of his mother is admitted in a private hospital manner. There are no other person on the old parents' father is there.
There is a loading of filing of I-212 of 2025. Is 30 not first item. The IA number 2.
Last report is 28 months. 28.
ଆଣିପାରିବେ
ଆଉ ସପ୍ତାହ
ତ ହଉଛି ସୋମବାର ଦିନ।
ये 3-2 था।
Next.
Item 3.
Next is CRLA number 7 of 20. Which order the pass करिए? I will say pass करिए.
Madam, last time you directed to take instructions.
I have taken the corporate certificate as well as the instruction result. So far the criminal antecedents is concerned. Nothing in the adverse against that.
It is 9 years, 4 months and okay. Your bail application was earlier rejected or it is coming for the first time? But for bail. How many appellants are there?
4, madam.
4.
Madam, I am one of them.
No, this criminal appeal Ramesh Panda, where is the appeal memo?
Madam,
One appellant?
413122. Madam, I am number 3122 by
Mr. Counsel, we are asking you how many appellants are there?
Madam, 4, madam. Madam, I'm only one, madam. Ramesh Panda.
Ramesh Panda is the only appellate.
Thank you.
So I'm asking you that whether you are earlier applied for bail, whether it has been granted or rejected. You are not aware. Your bail application one merit was rejected on 18/12/2018, right?
At the time of filing of the criminal.
What are the offenses here?
302, 307, 341, 34 IPC. In 302 life imprisonment and fine of rupees 10,000 and default further imprisonment of 1 year. And in section 307 IPC minor, sentence to arrive for 5 years and fine of rupees 5,000 in default 6 months. Under section 341 minor, 1 month simple imprisonment.
How many deceased persons are there?
Only one minor.
What is the name of the deceased?
December Biswara.
And who? How many injured?
Minor.
Injured persons.
Injured 2 minors.
Injured or
PW minor, that is minor 9 Padan Biswara, PW 10, that is Puddi Biswara.
PW 9 and PW 10
minor
are the 2 injured.
Minor.
And what they have stated against you?
Minor,
they have stated Ramesh Panda. What Ramesh Panda did?
Minor, that's it, minor. So PW 9.
4 persons assaulted on the right side forehead of the Pitambar by Lathi, who died at the spot. They also assaulted on the head of Putti by means of stone.
So 9 minor on normal cross exemption have a public prosecutor even according to the para 8 minor. It is a fact that I was examined by the police. It is a fact that I stated before I was holding short light and in the light of short light and the light of the motorcycle, I could identify the actual person.
What is the
My lord, that is my lord. The PW 9 and PW 10 has not corroborated the I'm not certain before against the concern accused was murder. All are same village, my lord. In the initial, my lord, they have gone to the from the village to Korea.
The fire was lost against unknown persons. They were identified in the TI parade and also in court.
My lord, but in the TI parade, PW 9 has identified the concerned appellant, my lord, but PW 10 has not identified, my lord. The magistrate, that is the PW 17, my lord. He has categorically stated that PW 9 has out of other accused person, my lord, he has identified only PW. That is the concerned present petitioner, present appellant, my lord. Otherwise, he has not PW 10, who is also eyewitness. He did not identify the concern of appellant.
Oh, PW 10 has not supported the prosecution.
No, man, how man, this man.
Okay. So, basing on the evidence of PW 9, this conviction has been.
So far, the doctor is concerned, my lord. He has categorically stated that the cause of death not due to the lathi or pelting of the stones, my lord.
But in cross-examination, he has answered.
Those 4 persons assaulted on the forehead of Pitambar by Lathi and that the doctor has stated that the injuries are not possible.
My lord. My lord, that is my lord. PW my lord. 17 my lord. 16 my lord.
PW 16.
My lord.
PW 16 is the PM doctor.
My lord. PM doctor as well as the injury examination doctor.
Acha. Injured to thila khali pot injuries. Dijon jaga.
My lord, that is cross examination.
It has one stab injury.
Conducted.
Stab.
Next page, para 3.
one stab wound on left side of cheek and one penetrated stab wound on the forehead lateral to nose breeze.
My lord, Father 5 cross examination by the defense minor. Injuries mentioned in Exhibit 13 and 14 are not possible by blunt object, by lathi. Such injuries are also not possible by pelting of stones, as in that case.
13 and 14 होची से जो injured गुड़ाक
Cutting wound पूरा
पीताम्बरର ଏଇଟା ହଉଛି
what wound ଗୁଡାକ
exhibit 15 पीताम्बरର TI पर ଏଇ ଯୋଉ PM report ଟା mark ହେଇଛି exhibit 15 ଆପଣ exhibit 15 ଉପରେ କଣ ପ୍ରଶ୍ନ ପଚାରୁଛନ୍ତି ଆପଣ ପଚାରୁଛନ୍ତି exhibit 13 ଆଉ 14 ଉପରେ ଯୋଉଟା କହୁଛି medical examination report of the two injured persons ହେଲା postmortem report ଟା mark ହେଇଛି exhibit 15 जो exhibit 15 ରେ stab wound ଅଛି sharp cutting weapon ଅଛି ଆଉ ବଡ injury ଗୁଡାକ ଦିଟା ବାକି ସବୁ abrasions ଗୁଡାକ
and even in respect of the injured he has rightly stated blunt side has not been used cut wound ଅଛି ପୁରା
The doctor said, I have prepared a rough report.
Mr. Naik, you have the deposition copy of that PM doctor. You'll find perhaps this injury number 2 is the main injury which resulted in the death because the other injuries are all abrasions and those are on the non-vital part of the body like knee joint 2 mm 1 cm एगुड़ाक तो मेन इंजुरी टा होची जो स्टाब वुंड टा देइचंती फोरहेड रे lateral to the nose breeze सेटा आउ गोटे स्टाब वुंड अछि सेथरे होची मेन गोटे जनरल देइतले opinion देवरा such injuries are what he is submitting that these injuries which has been caused to the deceased they are not possible by lathi you stab wound or penetrative stab wound because your case is that as per the evidence of PW9 who is the main eyewitness because the other witness has not supported the prosecution case so PW9 कहला जे 4 accused persons assaulted on the right side of the forehead of the Pitambar by lathi who died at the spot so that means लाठी रे तो स्टाब वुंड ही परिवन ना कि पंक्चर्ड वुंड हबनी हां who is the informant in this case
not PW6 my lord Ankura Harijana
PW9 ର ନାଁ କଣ
ପଦମ ବିଷୟରେ
PW9
PW9 she is also eyewitness
just a minute.
further December is concerned but ये सुनी की आसी the PW9 से I can read out the statement of PW9 I along with Pitambara Ankura
किए
PW9 sorry PW9
9
9
कौन कहले
PW9 eyewitness नहीं
हाँ injured and eyewitness
हाँ अब he is an eyewitness to the occurrence he has stated that by lathi these injuries were caused but the
injuries are
stab shot wound how can a lathi would cause such injury
and he has also been allowed to put leading question and nothing has been clarified there PW9 has also been confronted with leading question by public prosecutor This aspect has not been clarified.
Or the learning council for the petitioner learning council district as per the order dated 12/12/2024. The learning council for the state 12/12/8/1/2025. The learning council for the state has produced the report from the IIC Sinapoli police station, which indicates that there is no criminal antecedent against petitioner. The report is taken on record. He has also produced the custody certificate received from Superintendent Sub-Jail Karya, dated 8/1/2025, which indicates that the petitioner is in judicial custody for 9 years, 4 months. He is also taken on record. The Learned Counsel for the petitioner submits that the petitioner's bail application was earlier rejected on 18/12/2018. Submits that there are 2 eyewitnesses to the occurrence examined by the prosecution during trial, and they are PW9, PW10, but PW10 has not supported the prosecution case. So far as PW9 is concerned, he has stated that 4 persons assaulted on the right side forehead of the deceased, Pitambar Bisoi, by Lathi, who died at the spot. However, the doctor PW16 conducted postmortem examination and proved the postmortem examination report Exhibit 15 stated that apart from the abrasions on the non-vital part of the body, one penetrative star wound was noticed on the forehead, one injury on the one sharp cutting wound was noticed on the right eyebrow, and one stab wound was noticed on the left side cheek. And it is the contention of the Land Council for the petitioner that those injuries which are on the vital part of the body could not have been caused by the lathi, which are stated to have been used by the accused persons. He further submits that there are good chances of success in the appeal and balance of convenience which is in favor of the petitioner. And since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Learning Counsel for the state, on the other hand, opposed the prayer for bail and placed the evidence of PW9, PW10, to also PW16. Considering the submission made by the Learning Counsel for the respective parties, nature of evidence adduced during trial, period of detention of the petitioner in judicial custody, absence of any criminal antecedent against the petitioner, so also absence of any chance of early hearing, we are inclined to release the petitioner on bail alone.
Item 4.
Item directed my learned senior to serve a copy of the judgment.
Same day service.
But I'm submitted. Yes, yes, submitted and verified. Somehow it was not there in my record. I'm reading. Lordship, kindly pass over it as the last item. If you lordship take, but here is a case where there is extrajudicial confession and the family members have deposed, become hostile.
No, you are not having the file today.
No, I got the file, but I just, if your lordship kindly permits few passovers, I'll give.
No, raise this matter tomorrow.
Tomorrow, lordship.
Yes.
I'm so obliged.
Item 5.
May I please your lordship? My lord, offence under 302/34 IPC. My lord, custody since 29/3/2015. My lord, 2
convicted on section 302, 323, 34 of IPC lordship, the custody since lordship 7 years 6 months lordship. 24/6/17 is the custody date.
24/6/2017.
My lord. That's 7 years.
Aguru reject ହେଇନି ତ?
No, my lord. ଏବେ admit ହେଇଥିଲା.
So what is the prosecution case? Come to paragraph number 2.
4 lordship. Paragraph 4 lordship. The prosecution case in brief is that on 24/6/17, informant Kaushalya Khara, wife of deceased Jagu Khara of village so came to Chintrakonda police station and lost the FIR. It is alleged by the informant that about 1 month back, one he buffalo of accused Kartika Khilo and one she buffalo along with a male calf buffalo of accused Sadhu Hon'Ble were missing from the grazing field near Ramaguda. After such missing the buffaloes, they were searching for their stolen buffaloes and subsequently traced them in Balimala area. It is alleged by the informant that those two persons were alleging that her husband Jagu Khara had stolen said buffaloes. For that, they have called a meeting on 23/6/2017 by about 12 noon in village Ramaguda to discuss regarding that issue, and her husband Jagu Khara had also attended the said meeting. But the allegations brought by them against her husband could not be established, so that matter was subsided. In the said meeting, villagers of Ramaguda, Siddhipoka, Ghottakonda, Kotonpadar were also present, and after discussion, the matter was settled. So also everyone returned to their village. But on the same day, that is on 23/6/2017, by about 4 p.m., Kartika Khelo and Sadhu Hon'Ble came near their house and called her husband. And when her husband went out the same house, they started quarrel with him on the buffalo left issue and assaulted him by means of sticks and stones, due to which her husband was fallen down on the ground and sustained severe injuries in his person. Thereafter, the accused persons were took him by dragging to a little distance, and when she herself and other family members protested it, they did not hear anything, rather beaten them. After being so assaulted by the accused persons, sustaining bleeding injuries in his person, her husband was become unconscious, and thereafter Kartika Khilo assaulted her by means of a Kotturi near his neck, as a result of which the head of her husband was detached from his body. After committing such heinous act, Kartika Khilo and Sadhu Hon'Ble were fled away from the spot. It is mentioned in the FIR that due to sunset and darkness.
So what do you say? Say you assaulted by means of pottery, for which the head was completely detached from the body.
2, 3, 4, and 14 are eyewitness to the other.
2, 3, 4, and 14.
Also, 9 and 17 are also eyewitnesses, but though they have some contradiction statements, the court bill has not relied upon them.
No, it's all right. See, ଯୋଉମାନେ rely ନହେଲେ ଯେତିକି ସାକ୍ଷୀ ବର୍ତ୍ତମାନ rely ହେଲେ 2, 3, 4, 14 ଆଉ postmortem doctor. PM doctor କିଏ?
PW1.
PW1. ତ ତା ପାଖରେ ଗୋଟେ ମୁଣ୍ଡ ପହଞ୍ଚିଥିବ ଆଉ ଗୋଟେ ଇଏଟା ଦିଟା ଅଲଗା ଅଲଗା ପହଞ୍ଚିବ ନା?
Got injury at the level of thyroid cartilage. Neck was cut fully and head was separated from it.
Are the learned counsel for the petitioner, learned counsel for the state, in view of the eyewitness account of PW's 2, 3, 4, and 14, so also the evidence of the doctor bracketed PW1, and the fact that due to the assault of the appellant, the head of the deceased was completely detached from the body, by Kottari, है we are not inclined to leave the petitioner on the rejected. Yes, next. Pleasure.
Item 8.
Then on the section 372I, 762N, 8 and section 6 of the Poxo Act, sentenced to has undergo imprisonment for life. Custody. 72, 372I, 72N, 72F.
A victim
Just
the status कौन
he is married now. In a decreasing care stated that she is the mother of 2 children. So last week I documented so obtain the hospital certificate. He is the daughter of the step daughter of the applicant.
Father
Father, the father.
only father.
माने
बापा
जो ये बापा माने
Step father. छोटे उल्टा बापा the 164 statement is also there.
Yes, Grand Counsel.
File the bail application. Is under section 304 and 34 IPC. Even on last occasion, she has said to go for a custody certificate. And even I have obtained the deposition copy after taken.
What do you want?
Bail application.
No, have you obtained the custody
Yes.
certificate? So what is the period of custody?
8 years, 9 months, and 1 day.
8 years, 9 months.
Yes.
And offense is under section 302.
302 and 34 IPC.
Eyewitnesses are there.
Yes.
Huh?
Yes, ma'am.
Who is the eyewitness?
PW4 is the ID.
PW4.
Yes, sir.
Who is the deceased?
This is Kartik.
Kartik Pradhan is the deceased.
Kartik Pradhan.
Yes,
My
sir.
God.
Okay. You have filed bail application for only this JCRLA for Gayadhar Pradhan. So as it appears, 4 persons assaulted.
3 persons. 3 persons.
Ganga, Gaya, and Daya.
Ganga, Daya, and
Gaya.
Gaya.
No, how many persons face trial?
That's what I don't know.
What is judgment?
Judgment is there.
Judgment region or
Gangadhar Pradhan and Gayadhar.
One is absconding.
No, still absconding.
And who is the doctor?
PW6.
PW6.
My God.
Thank you. All incised.
His case is that all the accused persons were assaulting by Ujali, Kottari, and Tangi. That means all sharp cutting weapon. And incised wound 103.
Yeah.
Jari, fracturing issue.
8
compound fracture issue.
Inside injury 8 number.
8.
Number 8 tabhi incised. Eyewitness mother
Mother of the neighbor.
Mother of the neighbor.
Mother of the neighbor who was sleeping
by the side of
Yes.
this is.
Yes.
And PW1
is the neighbor.
is the informant.
PW1 is the cousin brother of the deceased.
Cousin.
are the learned counsel for the petition, learned counsel for the state. The learned counsel for the petitioner submit that the petitioner is in judicial custody for 8 years and 9 months. The paper book has not yet been prepared, and therefore there is no chance of early hearing. And therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail and place the evidence of PW, the eyewitness to the occurrence, told to PW6, the doctor who conducted postmortem examination and noticed number of incised wounds on the body of the deceased and determined that the
On the way with that, yeah, the doctor.
not from the and stated the injuries are antemortem in nature, and some of the injuries are previous in nature, but not to find the cause of death of the deceased.
PM report is there.
Hmm?
It is mentioned. Cause of death is mentioned.
Who did?
The PM report.
Now we are seeing the evidence. The evidence actually it is not there. However, the learned counsel for the state submits that in the postmortem report by exhibit 4, it is mentioned.
Yes.
देखिए exhibit देखिए.
Cardiorespiratory failure due to shock or hypovolemic resulting from multiple fracture.
Cause of death has been mentioned. The cardiorespiratory failure due to shock and hypovolemic resulting from multiple fracture and profuse bleeding from different parts of the body. In view of the nature of evidence adduced by the eyewitness, also the doctor who conducted postmortem examination, while not inclining to release the petitioner on bail, but taking into account fear of detention and judicial custody. We are inclined to release the petitioner on interim bail for a period of 3 months. Yes.
Item 10.
Then, madam.
Minor live committing on RI offense committed signature of parties. Delay in 38 days.
So it's a life conviction.
Minor.
क्या 302
Offense under section signature.
IA number 115 of 2025 is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 39 days.
38 days.
उसकी देख लीजिए स्टाम्प 39 days लिख लीजिए. After hearing the learned counsel for both the parties, and since it is a case where the petitioner has been sentenced to life imprisonment, we are inclined to condone the delay. According to delay is condoned, IA is disposed of, hard admit for the trial court record.
Item 11.
Convicted under section 326 and 302. of IPC. Maximum sentence is life imprisonment.
No, এটা
Not yet admitted.
delay ନାହିଁ ତ ଏବେ
No.
ଏଗୁଡାକ ଅର୍ଡର ସେକେଣ୍ଡ ଆସୁଛି ନୂଆ ମ୍ୟାଟର ଗୁଡାକ ଆଡମିସନ ଆସିବ ନା ଫ୍ରେଶ ଆଡମିସନ ହେଡିଙ୍ଗ ଡିଲେ ଥିଲେ ହଁ ତମେ ନେଇ ଆସିବ ତ ଡିଲେ କଣ ନେଇ ପୁରା ବି ଡିଲେ ଇଫେକ୍ଟ କିଛି ନାହିଁ ପୁରାକ ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ all for the trial to supply the deposition copy of the supply legal and counsel to interim applications for bail and stay realization of time to be considered after receipt of the trial court. Yes.
Item 19.
That's it. Where is Mr. Simon Das, he said that he will argue
Yes,
my please there.
That's it.
The Igaru difference. I don't speak Talmudi. Yes, Mr. Here, Mr. Rangi, the notification under Section 5 of the Special Court Act is under challenge. What is your prior alert? Let us see that. Who was that notification? Is it notification annexure 2? Yes, that is under Section 5 of the Special Code. Yes, please read that notification. Whereas it is alleged that the Pradeep Kumar Rao, so and so, State Odisha, while holding high public office in the state of Odisha, that is Accounts Officer, Odisha Rural Housing Development Corporation Limited, Bhubaneswar, committed an offence under Clause E of subsection 1 of Section 13 of the Prevention of Corruption Act, 1980, and that the matter was investigated in Bhubaneswar Vigilance case number 34, dated 29 November 2005. And whereas on scrutiny of relevant materials available on record, the state government is of the opinion that there is prima facie case of commission of the offence by Sri Pradeep Kumar Rao, who has accumulated properties disproportionate to his known source of income by resorting to corrupt means. And whereas it is felt necessary to expedient by the government that the said offender should be tried by the special court established under subsection 1 of section 3 of Special Court Act 2006. Now, therefore, in exercise of powers conferred under subsection 1 of section 5 of Special Court Act 2006, the state government do hereby declare that the said offence shall be dealt with under the Special Court Act 2006. The background is like this. And there is a date chart, though old, it's on record, 26/6/2023. The thought was not made relating to a DA case. There was allegation relating to misappropriated funds of the Odisha Rural Housing Development Corporation. During course of that, they found that they found nothing relating to that case. Then this case was instituted. It happened in 24/9/2005. Then date chart is kindly get. That is 26/6/23.
No, what is your main ground of attack on this Gazette?
Yes, madam. I'm coming. That's that. My main submission was, my position can no way as can be termed as holding high public office.
Just a minute. So this notification, if the state government is of the opinion that there is prima facie evidence of the commission of an offence alleged to have been committed by a person who held high public or political office in the state of Orissa, the state government shall make declaration to that effect, and so on. So what is that high public or political office? Is it been defined anywhere?
Yes, my lords, what they have done in the act, it was not there.
Yeah.
Your lordship has seen the special court act.
Yeah.
There, that was also one of the main arguments to declare it ultra vires. That it gives unfettered power.
Now thereafter they have brought these rules 2007,
where they have said belonging to group pay service.
Just a minute, let us see. Person holding high public office includes public servant falling within the meaning of clause C of section 2 of PC Act under section 21, the Indian Penal, then including the officer of so and so, and belonging to A of central so and so, or officers of equivalent rank in any organization specified in the explanation below so and so. We say that was
My humble submission is I don't come within any of these categories.
How the with the petitioner?
That's all.
What he was?
I was working on a temporary basis as an accounts officer. Initially, when we
accounts officer in which where?
Orissa Rural Housing Development Corporation Limited. It's a state government owned corporation. My appointment order is not there. I was appointed as accounts officer, then promoted virtual to the resolution. There is no fixed pay scale. I was never confirmed in my job. I don't have any police authority to take policy decision. So under nose, when I don't have a job at all, and I belong to a much
you were drawing salary or you were doing remuneration? What is?
Yes, that's what they have tagged.
Yes.
I will answer that. That is the only thing which came to light only after filing of the case. Before that, there was nothing before the Home Department.
So you Roman 2 रे कहला कि any person falling under the definition of the public servant under clause C of section 2 of the PC Act or 21 of the IPC, who has been appointed in the discharge of the so and so on any organization specified in so and so and receiving pay or honorarium or allowance of the service so rendered, it can also come within this definition.
Yes.
So you have what is your stand, Mr. Das?
My lord, I have prepared the written notes and submissions. And my lords,
how do you justify that he is coming under this person holding high office?
So far as the present matter is concerned, there is no dispute that he was holding a public post.
Public servant is
Public servant.
Public servant?
Yes, ma'am. And another thing is, Home Department has also filed an affidavit to this extent. And my lords, so far as the issue is concerned regarding the 5-1 notification, the language of the statute is opinion of the government. And earlier this matter had come up before another bench where my lordship had asked one question to the petitioner's counsel whether a writ is maintainable challenging the opinion of the government. And it has not been answered back thereafter. That matter was not listed before that court.
No, we are on a limited point. We are on a point that you see section 5 is made
Section 5.
very clear.
And your lordships has already decided 3 criminal appeals in the case of Sadanand Mishra's case.
No, we are just asking you that do you mean to say that every public or servant is to be prosecuted under this?
No, man.
So only the public servant who qualify this thing, that means they should be holding the high public or political office.
Yes.
And what is that high public? It is a political office, no? It is public office.
And that issue has already been dealt by this honorable court in the writ petition, where the validity of the statute was challenged in Divyadharshi Biswal's case, and again that was confirmed in the honorable Supreme Court in Jogendra Jaiswal's case. There, my lordship, this issue has cropped up, and basically V.C. Shukla's case that has been decided.
Okay.
My lordship, may I read the relevant portion of that decision, my lord?
No, we are
Here
going
we
to
have
the
to see.
decision.
Here. My lordship,
ଆପଣ ଖାଲି ଏଇଟା
when government counter ଟା ଟିକେ ଦେଖେଇଦେଲେ my lordship.
ନାଇଁ ଏଇଟା ଏଇ ଯୋଉ ଆକାଉଣ୍ଟ ଅଫିସର ବୋଲି ଥିଲା ଇଏ ଆକାଉଣ୍ଟସ ଅଫିସର ଏଇ ଯୋଉ ଓଡିଶା କଣ ORSDC ତେଣୁ ORSDC ରେ ଯୋଉ ଥିଲା ଇଏ ଆକାଉଣ୍ଟ ଅଫିସର ତାର କଣ ସ୍କେଲ ଅଫ ପେ ଥିଲା କଣ ଇଏ ଥିଲା ଏଗୁଡାକ ଆପଣ ଡିଟେଲ କରିଛନ୍ତି?
ଡିଟେଲ୍ସ ଟା ଖାଲି ମୁଁ ଯୋଉ government counter
sorry for interruption, boss.
Government
Your
counter
lordship directed that my employer, because they said we have filed documents, we don't have anything, and their counter could not satisfy the court. A specific direction was issued in 2015 that you produce to make my employer as a party. My employer has appeared, filed a counter stating that there is no job, we never implemented OSRP rules. That is there in record with us. Counter affidavit filed by the Orissa Rural Development Corporation. Thereafter, your lordship directed how this counter will be accepted. Your lordship's order, my lords. Last one order, it's a detailed order. Your lordship rejected that. It's not the answer. What the employer says, you have not done it.
One by one. We are not sorry.
Yes, my lords. Your lordship's order, detailed. Last one. Your lordship kindly have a look. Your lordship's order.
Mr. Das, perhaps he is referring to the counter affidavit which has been filed by M. Kumar Jha. M. Kumar Jha is opposite party number 2.
Yes.
This paragraph the paragraph paragraph number 8. 8 the key kotha ମାନେ D ଆଉ E ରେ ଲେଖା ହେଇଛି petitioner is holding the post of accounts officer in ORHDC which is not high public office. Petitioner is an employee of ORHDC having no decision making authority. So this is the thing.
It is there.
ତେଣୁ ଏଇଟା ହଉଛି ଆପଣଙ୍କର opposite party number 2.
Yes.
ଯିଏକି ହଉଛି
MD
managing director was. ତେଣୁ ତାଙ୍କର ଇଏ ରହୁଛି ଯେ ଏଇଟା ଗୋଟେ high public ଇଏ ନୁହେଁ office ନୁହେଁ which is one of the ingredients or requirement for publishing such notification.
Yes.
ତେଣୁ ଆପଣ ଆଉ କୋଉ basis ରେ
more basis my lords, I can refer to the affidavit filed by the opposite party number 1 as per your lordship's direction. That is dated 16/12/2024. Say through. Yes, sir.
Two paragraph.
My lordship, paragraph 6 ରୁ I'm reading out.
ସେଇ portion ଟା ଆମକୁ satisfied
ହଁ ସେଟା
ଏ ଯୋଉ high public
yes ma'am. That it is paragraph 6 that it is humbly submitted that government of Orissa in general administration
ଆପଣ in reply to ବୋଲି କହନ୍ତୁ ହେଲେ ଜଣା ପଡିବ କୋଉଠି ନହେଲେ it is humbly thereafter.
Yes, it is humbly
in Kajasuru
submitted that Government of Orissa in General Administration Department was pleased to publish a resolution bearing number so and so.
Where from we are reading again?
My lordship, this is the affidavit filed by the opposite party number 1.
1.
As per your lordship's
Paragraph?
Paragraph 6.
Paragraph 6 starts.
That in reply to the
That in reply to the
Subsequently, that on 16/12
another
affidavit is
This affidavit, your lordship rejected and by virtue of a recent order directed them to file again because it doesn't contain any answer. I have prepared a chart below so that comparison will be better.
Again.
Where is that again? You affidavit out of file to
I have prepared a chart. It contains the 3 affidavits details.
16/12. Here, Abhi Kumar.
The ତିନିଟା affidavit କୋଉ ପାରାରେ କୋଉଟା ଅଛି?
आगे हम ये रखें एडिशनल टा जो फाइल है ना रखे तो नंबर एडिशनल
ଆପଣ ଏଇଟା ଯୋଉ ପଢିଲେ ମିଷ୍ଟର ଅପୋଜିଟ ପାର୍ଟି ନମ୍ବର 1 affidavit ସେଇଟା ହଉଛି ଗୋଟେ ସୌମେନ୍ଦ୍ର ପାତ୍ର ବୋଲି ସେ ଫାଇଲ କରିଛନ୍ତି।
This is here Abhi Kumar.
Here, Abhi Kumar.
Here, Abhi.
Here, Abhi Kumar. Filed probably 16/12/24.
12/24.
କଣ କରୁଛନ୍ତି
Paragraph 6.
ये रवि कुमार बोली और की फाइल को opposite party number 1 we have.
It is pursuant to your lordship's order
No, no,
dated
ठीक है।
13/11/24.
Record का चेंज कौन पहुंचा? वो पैराग्राफ था।
Paragraph 6.
6.
No, page 3. May I read? That it is humbly submitted that Government of Orissa in General Administration Department was pleased to publish a resolution bearing number so and so, General dated 22/9/1995, by abolishing gazette, non-gazetted ranks classified Group A, Group B, Group C, and Group D employees, basing upon their respective pay ranges. Hence, the Government of Orissa, after taking into consideration of the grouping system of the Government of India, the suggestions of the Odisha Pay Commission 1983 and the revised scale of pay under the Odisha revised scale of pay rules 1989, decided to classify its employees into the following few groups. My lordship, Group A. We are concerned with Group A. Group A, all posts in the pay scales, the maximum of which is not less than 4,000. And in the next page, thereafter, basing upon the above resolution, the subsequent revised pay scales following the above group categories according to their respective pay scales that has been annexed. That has been annexed as Annexure A/1. That it is humbly submitted that on query by the vigilance authorities from Odisha Rural Housing and Development Corporation Limited, Bhubaneswar, the administrative officer in charge write their letter number so and so, dated 3/5/2017, and letter number so and so, dated 6/5/2017, has confirmed that since the date of joining, that is on 30/9/1995, the present appellant was designated as Assistant Accounts Officer, and through Housing and Urban Development letter number so and so, dated 18/2/2000, the appellant Pradeep Kumar Raut was redesignated as Accounts Officer, in which he has been continuing as such. So far as the scale of pay of the appellant is concerned, my lordship, here is scale of pay. And not so he has come to the scale of pay of the appellant is concerned. The same has been fixed rupees 8,275 to 13,500. My lordship, in 95 resolution it was 4,000. In 1990 resolution, it was 13,500. I will show my lords. 13,500 of ORSP rules 1988. It is worthwhile to submit here that according to the letter dated 6/5/2017 sent by the administrative officer in charge Orissa Rural Housing Development Corporation Limited, the scale of pay of the appellant was fixed in the scale rupees so and so 13,500 with effect from 5/5/2000 within the check period under ORSP rules 1998. That it is humbly submitted that as per government resolution under Annexure A by 1, that is the government resolution 95, the posts in the pay scale, the maximum which is not less than 4,000 to be termed as Group A officer. As the present appellant was drawing the pay scale of 8,000 with effect from 5/5/2000, he cannot take the plea that he was not holding the post of Group A officer status. The ORSP rule 1998 is applicable to him in views of the letter sent by administrative officer in fact Orissa Rural Housing Development Corporation. That the scale of pay of the appellant is being fixed under ORSP rules 1998 pursuant to Annexure B by 1 series, and during the raid by the vigilance authorities, the appellant was drawing a Group A scale. So it is clear, my lords, that it is humbly submitted that in Kajas, Suryanarans, and there are different. And here, my lordship, in that decision, next page, page 6, prima facie evidence means on the face of it there is a ground for proceeding. It is not the same thing as proof which comes later, that the court has to find whether the accused is guilty. It signifies that on first examination, the matter appears to be self-evident from the fact. In common law jurisprudence, prima facie case denotes evidence which, unless rebutted, would be sufficient to prove a particular proposition or fact. And similar view in Anil Kapoor's case. So, my lordship, here the documents I have shown, and your lordship will see the documents. First,
so you mean to say that? Yes. You mean to say that in view of the scale of pay,
yes,
it indicates that he belongs to Group A service.
Group A, sir.
Once he belongs to Group A service, then as per the definition which is there,
yes,
under these 2007 rules,
yes,
2E,
yes,
he comes under this person holding high public office.
Yes,
so therefore, notification is justified. Yes, Mr. Padangi.
These stand laws, they have already taken. This is a copy of the vigilance, the previous affidavit. They annex the vigilance document and said that we adopt that counter. That your lordships rejected. 13/11/24, your lordships order. Thereafter, this counter has been filed.
Yes.
Here, instead of saying adopting, they have copied the vigilance counter. Now, my lords, these two documents, the same documents are there in the vigilance counter, which was filed on 3/7/2017. Lordship, kindly have a look. Same document, same copy. I am not on copying. I am on the documents they have relied upon. Well, the notification is 2014. My lord, may kindly have a look. The document just now handed over to your lordship. The counter. Lordship got it?
Yeah.
They are probably. My lord, may look at page 13. Kindly have a look. That is why they say I belong to Group A. Lordship got it?
Yeah.
May I place it, my lord? Date of joining, nothing to do. Para 4. In the year 2002, the scale of pay of Sir Pradeep Kumar Raut was so and so under OSCP rules regarding status, example, class 1 or Group A, B, etc. No specific information available in this office. This letter, my lord, is dated 2017. So when the notification was made or when they referred, they didn't have anything. And this is not, then again, the next page below, same.
No. So far, group of officer is concerned, Group A, that has been issued in 1995.
No, I am not on that, below.
Yes.
The information supposedly they are relying upon, stating that we have considered this on this basis we have done. This information is dated 2017. First letter, when they say we do not know anything about the group. Next page, they forced the ORICC, got the second letter in 2017. Again, specifying the scale of pay of fixed under OSRP rules. Whereas my employer, thereafter, Milors, this court, he is saying after 9 years maintainability, the honorable judge who passed the initial order and made the party, he was a party to the judgment challenging the special court act.
Both letters have been issued by the.
Let me complete first. You will answer.
Yes, yes.
So, no maintainability, judicial review, Khudiran's case is still there. And I am thankful, even if your lordship remembers that special court act, when it was challenged, the state government's plea was, it is already decided in BG Sukla's case. Now, I will cite those documents. We will come to that now. So, these documents were filed into. So, I have given the chart. Whatever he has read from this counter, setting that a trace counter by the state, it was already there in 2017. Being dissatisfied, my employer was made a party. My employer says no OSRP rules has not been implemented in the corporation till date. I don't have a chair. I don't have my service is not confirmed. I don't have any decision making authority. And VC Shukla case 1, 2, 3, 4, 5, it's specified. What will be, who will be a person holding highly placed public office?
You do not have a chair, you do not have a, how do you
my lord, may kindly have a look.
No, you were
temporary employee.
You were designated as accounts officer or not?
Yes.
That is there?
Yes.
Whether the notification 2017 is within the check period or not?
I am not on that, my lordship. Your lordship is not getting. Then your lordship may kindly have a look at my employer's counter and your lordship's order.
No. That is there.
That is there.
That is
my lord, these documents came to existence not in the time when the notification they made. Subsequently, after filing the case, they in the counter they introduced this. They asked. That is the dispute. Because of that, thereafter, in 2017, when this counter was filed, my employer was made a party. Now my employer's counter, milords, kindly have a look. Dated 12/9/2017. I am placing the whole thing, milords, for convenience. That will clarify the position. Even may I place it, milords?
Yes. You would have placed
12/9/2017. Counter affidavit filed by the opposite party number 2. The aforesaid writ petition, para 1, challenging the Odisha government. So and so, it's not relevant.
What are relevant?
Para 5, my background starts. Para 3 is partly correct. The extent working as petitioner's assistant accounts officer in ORBC since 95. Initially, the petitioner was receiving a sum of rupees 3,500 per month as consolidated remuneration for his work.
Appearing for that opposite party number 2? With the council?
Well, they are in the other day.
With permission, I am Sandeep Kumar Mishra on behalf of Sri S.K.Sahoo my lordship. I am appearing to the VC my lordship.
Yes.
S.K.Sahoo is the council, he says on his behalf is appearing.
No. This
Orissa Rural Housing Development Corporation.
Yes, party number 2.
Who is appearing? S.K.Sahoo is appearing.
Yes, my lordship.
Where is S.K.Sahoo?
My lordship is out of station due to some personal difficulty.
Out of station?
Yes, my lordship.
So you must come out and say.
Come say and answer these things. Have you received the now the present counter affidavit which has been filed on 16/12/2024?
No, my lordship, I have not received the copy.
Submit your reply on this counter which has been filed.
My lordship, copy may be served. Will reply to that counter.
These documents, milords, were already there.
This is not on record. We are placing it on record. Here just it has been handed over. It is his copy. Take down. He it appears that in pursuance of the order dated, ଆମେ କେବେ କହିଥିଲୁ ସେ order ଟା?
13/11/2024
କେବେ?
13/11/2024
ଏଟା ଗୋଟେ detail order pass ହେଇଥିଲା।
Yes, that's what I am hinting at, my lordship.
We have passed that order on 13/11.
Yes.
13/11/2024. This one K. Ravi Kumar, who is the Deputy Secretary to Government Department, has filed an affidavit on 16/12/2024. However, the said affidavit is not on record. Recorded nahi na? Acha, let the registry place the same on record. Mr. Sarangi and counsel submits that he has received the copy of the affidavit filed by the opposite party number 1 dated 16/12/2024. However, Mr. C.DASH and counsel who is appearing opposite party respondent or respondent number nahi C.DASH
1 2
respondent number
ORSDC.
Orissa Rural Housing Development Corporation submits that he has also not received the affidavit filed by the opposite party number on behalf of opposite party number 1 dated 16/12/2024. Mr. Devasis Sarangi pointed out from the counter affidavit filed by opposite party number 2 that the petitioner was holding the post of accounts officer in SDC Limited, which is not high public office, and the petitioner is an employee of RHDC Limited having no decision-making authority. Or you are looking at counter affidavit. It has been filed by the managing director of SDC, one Prem Kumar Jha. However, in the affidavit filed by Mr. K. Ravi Kumar, it is stated that since the petitioner was drawing the scale of pay which comes under Group A official. Therefore, in view of the definition of person holding high public office as for section rule 2E of Orissa Special Court Rules 2007, the petitioner comes under that category, and therefore the notification issued by the notification under annexure annexure 2 na annexure 2 issued by the government in exercise of the power conferred by subsection 1 of section 5 of the Special Court Act 2006 is quite justified. The let a copy of paragon, let a copy of the affidavit filed on behalf of opposite party number 1 be handed over to the London Council for the respondent number 2. Will file an affidavit on the affidavit filed by the opposite party number 1. ଆପଣ କଣ କହିବାର ଅଛି এই affidavit উপরে ତାକୁ file କରନ୍ତୁ ହେଲା କାରଣ ଯୋଉ stand ନେଇଛନ୍ତି it is completely contrary to the recent affidavit. So you clarify it and we'll take up this matter. We are granting you 2 weeks time of this matter in the week commencing from 17th of February 2025. We use registry place on record with the affidavit asini record.
These two documents were filed by the Vigilance Department in their counter. Thereafter, the order has been passed, and thereafter, this affidavit has been filed. It has been same copied. That is the reason I filed a charge. Submission is satisfied. More submission end satisfied. Not satisfied.
Memo dekhi raha hai khali